ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಆಕ್ಸೆಸ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ, ಈ ತರ ಟೈಟಲ್ ಬರುತ್ತೆ. ಅದು ಕ್ಲೋಸ್ ಮಾಡಿ.
Any mentionings through video?
Serial number 55, mal. 55 serial number.
Yes.
ಇದ್ರಲ್ಲಿ KSRTC ಅವರು ವಕಾಲತ್ ಇವತ್ತು ಕಳಿಸ್ತಾ ಇದ್ದಾರೆ, ನಾನು ಫೈಲ್ ಮಾಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Yes.
ಮತ್ತೆ ಸೀರಿಯಲ್ ನಂಬರ್ 63 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 63
yes.
ಇದರಲ್ಲಿ DS ಶ್ರೀಧರ್ ಅವರು ಇದರಲ್ಲಿ ಇಲ್ಲ, ವಕಾಲತ್ ನನಗೆ ಕಳಿಸ್ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಅವರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. ಇದೊಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ ಇದೆ ಅಲ್ಲಿಗೆ ಫೈಲ್ ವಕಾಲತ್. ರಿಲಯನ್ಸ್ ಕಂಪನಿ
64 मिला.
much obliged.
64 मिला. Yes, madam. Weeks time. Yes, madam. I will pay for the connected appellant ke first only respondent. Next week, madam.
Counsel for the appellant in MFA 227. As finally a week's time is granted, making it clear that since the appeal is of the year 2018,
Please.
no further judgment would be granted in the matter. Yes.
See number 56, my lord. 56.
Yes.
Kindly, it may be referred to Lok Adalat.
When is the Lok Adalat scheduled? No idea. Why don't you report the settlement before the court itself? Today itself, matter would be disposed of. Why are you anticipating and waiting for Lok Adalat?
ಅದು ಅವ್ರ ಜೊತೆ
ಏನೋ ನಾಳೆ ನಾಡಿದ್ರಲ್ಲಿ ಮುಂದಿನ ವಾರ ಆಗ್ತದೆ ಒಂದ್ ಲೆಕ್ಕ. Lok Adalat is for early settlement. This court is for earliest settlement.
I am also. ಆದ್ರೆ ಈ ಕೇಸು ತಮ್ಮೆದ್ರಿಗೆ ಬೇಡ ಅಂತ ಹೇಳಿ ನಾನು ಒಂದ್ಸಲ
ಆಗ್ಲಿ. ಯಾಕೆ ಅಪಾಟಿವ್ ವೈರಸ್ಗಳಿದ್ದಾವೆ ಅಂತಲ್ಲ.
ಹಂಗಲ್ಲ ಸ್ವಾಮಿ.
At the request of the legal counsel for the appellant, a week's time as paid is granted. ಬನ್ನಿ ಇಬ್ರು ತಯಾರಾಗಿ settlement ಮಾಡ್ಕೊಳ್ಳಿ ಒಂದು ವಾರಕ್ಕೆ. Yes. Call the cases. Any mentioning, any memos? Any memos?
I am appearing for the respondent. This is the claim owner's appeal. 50% amount is being deposited. It's not been listed for admissions. 21 matter.
Yes.
Serial number 32, madam.
Mentioning, yes.
There is 1 week time.
Serial
for 32, madam.
It is for notice. We will see when the matter reaches. Yes.
Lord, serial number 35, my lord.
Yes.
We are for appellants. Require a week's time, my lord.
Same. It is for notice. We will see. Come with a dispensation memo on deserving case. Yes.
Being the appellant, being the driver of the vehicle, offending vehicle, file the appeal and sought for the stay of the High Court judgment.
Fresh matter.
Fresh matter.
Provided office objections are completed with.
Subjections have complied.
It's called the case.
Fresh matter still number 1, Ravi Shankar Shartji.
For the appellant, my lord, R1, my lord, I need to seek dispensation, my lord. R2 is united. That, my lord, parents and brother are the claimants.
United India.
Respondent number 2, United India Insurance Limited.
Notice. R1 dispense with. Dispense with. R2, Shri so takes notice, copy for you. For the directed furnished copies, TCR. Yes.
Non-compliance of office objection second time, serial number 2, Sharadamba AR.
Consider as finally abused time is granted to comply office objection, making it clear that in case office objections are not complied within the said time, the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance as well for non-prosecution. List the matter on 11-4. Yes.
Non-compliance third time, serial number 3, Shivagondappa.
If 1 week time.
Rejected.
Madam?
Rejected.
Some personal inconvenience, madam.
ಅದನ್ನ ಹೇಳ್ಬೇಕು. ಒಂದೋ ಯಾರೋ ಸಾಯ್ಬೇಕು ಅಥವಾ ಯಾರೋ ಬೇನೆ ಬೀಳ್ಬೇಕು ಅಥವಾ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗ್ಬೇಕು ಅಥವಾ ಮನೆಯವ್ರು ಬೇಗ ಬರ್ರಿ ಅಂತ ಹೇಳಿರ್ಬೇಕು ಅಲ್ವೇ? Request of the learned counsel for the appellant as a final last opportunity, a week's time is granted, making it clear ಮುಂದಿಂದೆಲ್ಲ ಹಾಕಿ in case not complied. 11-4. Yes.
Fourth time, serial number 4, Pavadegoda.
Probably you may have to file a recalling application. Probably you may have to file a recalling application.
Not aware of.
500 rupees per day, maximum 7 days. How many days you want?
First time, my name is reflecting in this case.
ನಿಮ್ಮ ನೇಮ್ ಯಾವಾಗ ಬರ್ತದೆ ಇಮ್ಮೆಟೀರಿಯಲ್. ಈ ಕೇಸಿನಲ್ಲಿ ಎಷ್ಟು ಅವಕಾಶ ಕೊಡಲ್ಪಟ್ಟಿದೆ ದಟ್ ಇಸ್ ಮೆಟೀರಿಯಲ್. ತೊಂದರೆ ಇಲ್ಲ, ಹಾಗಾದ್ರೆ ಈಗ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರ್ತೇನೆ ನಾನು ನಾಟ್ ಕಂಪ್ಲೈಡ್ ಅಂತ. ಇವತ್ತಂತೂ ತಾವು ಬಂದಿದ್ದೀರಿ.
Next time.
At the request of the learned counsel for the appellant as an ultimate opportunity. 3 days time as period is granted to comply all of his objections, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. In case if the office objections are not complied with, then list this matter on 10-4. Yes.
Serial number 5, Harish Kumar.
None appear for the appellant either physically or through video conference. 17/3/2023, I made the following observation. Right of the above observation, either the office objections are not complied with, nor any reasons are shown for non-compliance of office objections. Circumstantial dismissal for non-compliance of his objection as well as for non-prosecution.
Fifth time, still number 6, Jagannath HT.
Partly complained regarding the statutory deposit, I may be permitted to make a submission. I filed NOC Vandal on 23/9/2022.
Two option, 1 day and a cost of rupees 1,000 or dismissal, you can file a recalling application. Economically, the second option would be viable. Because recalling in the changed roster without any cost, that will be allowed.
Regarding statutory deposit, I may be permitted.
There are more objections than one.
I'll comply with end of the day.
1,000 rupees. 1,000 rupees.
Regarding statutory deposit, I may be permitted.
All those things you have to tell them. If they can waive, waive. Initially, any submission regarding the office objection to be heard by the concerned registrar. Let him do his job. If he is not convinced with your submission, then the court would hear. Somehow pay cost 1,000 rupees today and see that the matter won't appear for another 3 weeks. Fine. Good. The counsel for the appellate physically present. Address for a day's accommodation to comply of this objection. Since several and sufficient opportunities of not less than 5 times have already been granted. Supposing it passes off. 500 payable by the appellant to the legal services committee of this court. In forum session and filing a complaints memo along with the receipt of that in the registry. In the said time, a day's accommodation as an ultimate opportunity is granted to comply of this objection.
Still number 7, Venkatesh PR.
Yeah, very important. Value. Mentioning the para 8 of 18.
Same ಹಿಂದಿಂದ ಏನಾಯ್ತು ಅಷ್ಟೇ.
Already paid. Today I paid before already.
ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. There are more number of office objection, not just confining to court fee. ಎಲ್ಲ ಗೊತ್ತಿರ್ತದೆ, ಗೊತ್ತಿದ್ರು ಏನೋ ಒಂದು ಕಲ್ಲು ಒಗಿತೀರಿ, ಬಿದ್ರೆ ಬೀಳ್ಲಿ ಮಾವಿನ ಹಣ್ಣು ಅಂತ. ಇನ್ನು ಸೀಸನ್ ಬಂದಿಲ್ಲ, ಬೀಳಲ್ಲ ಮಾವಿ.
ಅದರ್ ಆಫೀಸ್ ಸಿನಾಪ್ಸಿಸ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಸುಮ್ಮನೆ ಸೆಕೆಂಡ್ ಸೆಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ. ಅಂಡ್ ಅನದರ್ ಒಂದು ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ಇದ್ರದ್ದು ಹೇಳಿದ್ವಿ ಸರ್ 18.
ಅದು ಬಿಟ್ಟು ಬೇರೆದು ಇದೆ.
ಅದರ ಸಿನಾಪ್ಸಿಸ್ ಅರ್ಲಿ ಆಸ್ ಪರ್
ನನಗೆ ಗೊತ್ತಿಲ್ರಿ, ನಾನು ಯಾಕೆ ನಿಮ್ ಕ್ಲರ್ಕ್ ಕೆಲಸ ಮಾಡ್ಲಿ? ಅದಾಗಿದೆ, ಇದಾಗಿದೆ, ಇದಾಗಿಲ್ಲ, ಅದಾಗಿಲ್ಲ ಅಂತ. ವೈ ಶುಡ್ ಅಟೆಂಡ್ ಯು ಆಸ್ ಅ ಕ್ಲರ್ಕ್? What submission you made? Beyond that, there are some more objections. That's not my lookout to tell you what those objections are.
Today I complained.
1,000 rupees, same order. If same order. 500 rupees.
Orders matter, still number 8, Shri Padmi Shastri.
Lord, I am for appellant in 2 appeals and respondent in 9815 of 18. Lord, these 3 appeals arise from the common accident. My Lord, in my appeal, my Lord, 8805 of 17, my Lord, it is disposed of separately, and I took the steps, process paid. But R2 is the insurance company. O Mahesh is appearing in the connected matter. So I will serve the copies on O Mahesh as far as R2 is concerned. R1 and R3 await antide.
1 minute.
Sir, just a minute, sir.
In MFA 8805 of 2017, my lord, service is not yet completed.
Just for clarity, my lord, may I make one submission?
1 second. In MFA 8805 of 2017, even though the respondent number 2 is the appellant in MFA 9815 of 2018, and the learned counsel appearing for the appellant in 9815 of 2018, the insurance company may be directed to take notice for the respondent number 2 in MFA 8805 of 2017. Now the question would be, why can't this court order of denial of interest till the service of notice upon respondent number 1 in MFA 8805 of 2017?
ಅದ್ ನೋಡೋಣ ಸ್ವಾಮಿ, ಫಸ್ಟ್ ಅವ್ರು ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
ಇಲ್ಲ ಅಷ್ಟೊಳಗೆ ರೋಸ್ಟರ್ ಚೇಂಜ್ ಆಗಿದೆ.
ಆಗ್ಲಿ,
ಸಾಧ್ಯ
ಗುಬ್ಬಿ ಮೇಲೆ ಬ್ರಹ್ಮಾಸ್ತ್ರ ಬೇಡ ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು.
ಅಲ್ಲ ಬೇಕಾಗ್ತಿದೆ ರೀ. ಅಯ್ಯೋ 5 ವರ್ಷ ಅವ್ರು ಪುಕ್ಕಟೆ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ಬೇಕೆ? ಅವ್ರು ಮಹೇಶ್ ಏನೋ ಕೊಡ್ಬಹುದು, ಹಿ ಇಸ್ ರಿಚ್, ಬಟ್ ದಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇ ನಾಟ್ ಬಿ ಆಸ್ ರಿಚ್ ಆಸ್ ಮಿಸ್ಟರ್ ಮಹೇಶ್.
ಅಲ್ಲ, ಅದು ನಮ್ ದುಡ್ಡೇ ಸ್ವಾಮಿ, ಅವ್ರ ಹತ್ರ ಇರ್ತದೆ, ಅವ್ರಿಗೆ ಏನ್ ಎಕ್ಸ್ಟ್ರಾ ಬರ್ಡನ್ ಆಗೋದಿಲ್ಲ. ನನ್ ದುಡ್ಡನ್ನು ಅವರು ಎನ್ಕ್ಯಾಶ್ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ.
ಇಲ್ಲ
ನೋಡೋಣ ಈಗ ಒಂದ್ಸಲ. ಅಲ್ಲ, ಈಗ
ನಾನು ನಿಮಗೆ ಇದ್ರಲ್ಲಿ ಸಡಿಲತೆ ತೋರಿಸಿದ್ರೆ ಅದೊಂದು ಪೂರ್ವ ನಿದರ್ಶನ ಆಗಿ ಬಿಡ್ತದೆ. ಇಲ್ಲ
ಅಲ್ಲ, ಈಗ ಅವ್ರು ವಕಾಲತ್ ಹಾಕ್ಲಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬಂದಾಗ ನೋಡ್ಕೊಳ್ಳೋಣ ಸ್ವಾಮಿ. ಅವ್ರು ವಕಾಲತ್ ಹಾಕ್ಲಿ, ಆಮೇಲೆ ನಂಗೆ ದಂಡ ಹಾಕೋದಿದ್ರೆ ಹಾಕಿ ಸ್ವಾಮಿ. ಈ ಫಸ್ಟ್ ಅವ್ರು ವಕಾಲತ್.
ನಾನೀಗ ದಂಡ ಹಾಕ್ತಾ ಇಲ್ಲ.
ಅಲ್ಲ,
ಅದರ್ ಸಬ್ಮಿಷನ್ ಇನ್ ದಿಸ್ ಮ್ಯಾಟರ್.
Serial number 8.2 nalli my name is shown, my lord, as advocate for respondent number 2. The senior counsel Mr. Omesh has already filed the appeal on behalf of the company, so my name will be deleted, my lord, and Omesh may be directed to take notice on behalf of the insurance companies. 8.2 nalli
881 of 2019.
881.
I have not filed.
Are you agreeable, Mr. Omesh?
Lord, if the copy is served on me, my lord, because it is.
ಅಲ್ಲ, ಅವರ ಕೆಂಪಣ್ಣ ಬಡಾವಣೆ ನನ್ನ ಬಾಯಿಲೆ ಇದೆ ಅಡ್ರೆಸ್, ಹಾರ್ಡ್ ಕಾಪಿ ಕೊಡ್ಬೇಕು, ನಾನು ಕಳಿಸ್ತೇನೆ ಸ್ವಾಮಿ.
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಪರವಾಗಿ ಓಮೇಶ್ ಅವರು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ. ಸೊ my lord, he may be the right person, my lord, to take.
ಕಳಿಸ್ತೇನೆ ಸ್ವಾಮಿ ಅವರಿಗೆ. By post I have to send. I will send.
There are counsels for appellant in all these 3 matters. Respondent number 2 in MFA 881 of 2019 are appearing through video conference. There are counsel for the appellant in MFA 8805 of 2017. Submits that since the respondent number 2 in the said appeal is the appellant in MFA 9815 of 2018. The learned counsel appearing for the appellant in MFA 9815 of 2018 will be directed to take notice for respondent number 2 in MFA 8805 of 2017. Next line. In the light of the above, learned counsel Sri O. Mahesh appearing for appellant in 9815 of 2018 is directed to take notice for respondent number 2 in MFA 8805/2017. The learned counsel Mahesh accepts notice for respondent number 2 in the said appeal. The learned counsel for the appellant in MFA 8805/2017 is directed to furnish the copy of the memorandum of appeal along with annexures CPNE, annexures and IAs, CPNE to the said learned counsel for respondent number 2 within 3 days from today.
ಅದನ್ನ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅವ್ರಿಗೆ. ಇವತ್ತೇ ಪೋಸ್ಟ್ ಮಾಡ್ತೇನೆ.
In a week from today.
In both the matters.
Both the matters.
Learned counsel for respondent number 2 to file his wakalat and statement of objection if any to IA at 1/17 within 2 weeks from today. Next line. A perusal of the order sheet would go to show that in MFA 8805/2017, the emergent notice to the respondents were ordered as long back as on 25/9/2018, more than 4.5 years back. However, till date, the appellant has not made good the deficit process fee. The registry, thus, the issuance of notice to the respondents could not be possible for such a long years, only at the instance of the inaction on the part of the appellant. Hence, in the said circumstance, the respondents should not be burdened with liability to pay the interest for the delayed period in case if the appellant succeeds in the appeal. As such, it is ordered that in case the appellant succeeds in this appeal, he would not be entitled for interest from the date of order of notice to the respondents, that is on 25/9/2018, till the respondent number 1 is served. Next line.
In my appeal, my lord,
In MFA 881/2019, learned counsel Sri H.N. Keshav Prashant, who has taken notice for respondent number 2, submits that since the said respondent number 2 is being represented by learned counsel Sri O. Mahesh in other 2 connected matters, he may be permitted to retire from appearing for respondent number 2 in the said appeal. And learned counsel Sri O. Mahesh be directed to take notice for respondent number 2. Next line. Learned counsel Sri O. Mahesh accepts the notice for respondent number 2. As such, registry not to show the name of learned counsel Sri H.N. Keshav Prashant for respondent number 2 in MFA 881/2019. Learned counsel for the appellant in MFA 881/2019 to furnish copies of the memorandum of appeal along with annexure CPNE to the learned counsel Sri O. Mahesh appearing for respondent number 2 within a week from today. Call for TCR.
Lord, in my appeal,
Yes.
98/15/2018, my lord,
Yes.
R3 has been served by paper publication. It has been produced. It may kindly be accepted. MFA 9815/2018.
1 minute. 1 minute.
that we did.
In MFA 9815 of the 2018, the appellant has filed a newspaper publication along with the memo. In the registry on 10/3/2023. However, it appears that the registry has not scrutinied the said paper publication, whether the same is in accordance with the order made on 13/2/2023, permitting to carry out the paper publication. Needless to say that when such paper publications are filed, it is for the registry to scrutiny the same and along with its endorsement regarding the correctness of carrying out of the paper publication to place the said paper publication before the court within time. The Registrar Judicial and the Learned Registrar General to instruct the concerned officials in the registry in that regard. Next line. Paper publication filed today and filed
2/3/23.
ಎಡಿಷನ್ ಯಾವುದು ನೋಡ್ತಿದ್ದೆ?
ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ ಚಿತ್ರದುರ್ಗ ಎಡಿಷನ್.
ಚಿತ್ರದುರ್ಗದಲ್ಲಿ ಅವ್ರ ಎಡಿಷನ್ ಇಲ್ರಿ.
ಅಲ್ಲಿ ಒಂದ್ ಪೇಜ್ ಇರುತ್ತೆ ಚಿತ್ರದುರ್ಗ ಎಡಿಷನ್.
Yes, the paper publication carried out in Sanયુક્ತ Karnataka dated 2/3/2023 as a substituted service of notice to respondent number 3 is accepted. Respondent number 3 called out. See Raju KG.
Raju KG, respondent number 3.
Respondent 3 has remained absent. Yes, Amit PCR, all PCR in all the units.
Accepted, my lord.
Three matters are wrong connected.
Yes.
Seal number 9, Rangegoda NR, BM Sitappa for respondent number 1. Connected.
The counsel for the appellant. Of the counsel on behalf of the appellant. My lord, by the earlier order dated, Lord, this court had directed the medical institute, medical board constituted by the assignment to assess the permanent disability of the claimant and if any functional disability, and to send back the report to this honorable.
That regard, what is your submission?
That
That is the previous observation.
that report has come before this court. Lord, appellants, my lord, they have challenged the quantum and the assessment of disability.
Counsel for the appellant. Learned counsel for respondents are present. Learned counsel for respondent 1 and 2 are granted 3 weeks time to file their vocalic in the matter before proceeding further in the matter. Yes.
Seal number 10, Shripad V. Shastri. P. Pradeep for respondent number 2.
Lord, I am for appellant.
The cause list is there. Again, ನಾವು ಇದ್ರೆ ಡೌಟ್ ಅಂದ್ರೆ ಕೇಳಬೇಕು. ಯಾವುದಕ್ಕೆ ಆರ್ಡರ್?
Notice to R1 may dispense with.
Or dispensation. TCR. Yes.
Seal number 11, Sridhara DS, B. C. Shivanegoda for respondent.
considered as 28 of 2019.
Are seeking dispensation to R1 and R2.
Unclaimed, R1 and R2, they are unclaimed.
Therefore, what is your submission in that regard? Because of the microphone, please.
Should be considered as game service. So they are unclaimed in what case?
Should be or maybe. It should be considered or may be considered. If you say may I consider, if you say should I, leave it to you to write order. Which one you prefer? Couldn't catch the point. Leave. Service is not proper. You cannot be accepted as deemed service. Counsel for the appellant, appearing physically, submits that in view of the fact that the notices sent to respondent number 1 and 2 have been returned as unclaimed, the service against R1 and R2B that is sufficient. A perusal of the written portion cover go to show that, except mentioning single comma as unclaimed or oblique sender. That's neither in signature in the endorsement nor any endorsement about delivery of the intimation to the addressee regarding the arrival of the postal article. As such, the postal shara as unclaimed cannot be accepted. Now, you can file memo seeking dispensation. Body. The counsel for the appellant files a memo seeking dispensation of notice to R1 and R2. Dispensation. TCR. Yes.
Still number 12, Shantraj K. EI Sanmati for respondent number 2.
So present R1 dispense TCR. Yes.
Still number 13, Jagdish Gundappa.
Present another new video hackಬೇಕು ನಾನು ಹೇಳೋಲ್ಲ.
HS Lingraj. Ma'am 2.
R1 dispense with the TCR. Yes.
Still number 14, Harish Babu KN. Ravi Samprati.
Mr. Harish Babu appear for appellant for praise for dispensation of issue of notice. Respondent number.
R1 dispense with TCR.
Still number 15, Guru Prasad BR. Lata Prasad for respondent number 1.
I'm appearing for the appellant, my lord. I'm seeking dispensation of notice to. I'm seeking dispensation of notice to R2, my lord, who is the owner of the offending vehicle. Liabilities on the insurance company.
I appear for R1, my lords.
R2 dispense with TCR.
Please, my lord.
Still number 16, Shantraj K. Janardhan Reddy. For respondent number 2.
R1 dispensed with. I8. Request of Plaza Council for all to 10 days time is granted to file objection if any to IA1 got.
Still number 17, Shantraj K. Ravi Saprati for respond number 2.
R1 dispensed with PCR. Yes.
Still number 18,
By the number dispensing of notice to R1. What is a Reliance company?
Yes.
respond number 2, Reliance. Generation Limited.
Three bar 22 by Ashok and Patel.
Dispensed with. Reliance ಯಾರಿಲ್ವಾ? Yes. R2 steps ತಗೊಳ್ಳಿ ಯಾರಿಲ್ಲ ಹೋಗ್ತೀನಿ. What is step? It is here.
Still number 19, Basuraj TG. Respond number 2, Tata AIG Generation Company Limited.
R1 dispense. R2. This so and so takes notice. Copy delivery. Within 3 days. PCR.
Still number 20, Ganapati.
I'm for the appointment. I'm protecting the rectified award and I better fix permit by insert the same in the file. Okay, there is a mistake in the name of the response number 3. Instead of IFCO, it's your type as
ಕಾಫಿ ಹಾಗೆ ಕೊಟ್ರ ಕಾಫಿ ಕುದಿಸಿ ಕೊಟ್ರ ಕೆಳಗಡೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ವಿ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ನೋಡಿದ್ದೆ ಇಮಿಡಿಯೇಟ್ಲಿ ರೆಕಾರ್ಡ್ ಹೋಗಿದ್ದ ಫೈಲ್ ತೆಗೆದ್ಬಿಟ್ಟು ಸೆಂಟ್ರಲ್ ರೆಕಾರ್ಡ್ ಹೋಗಿತ್ತು ವಿತಿನ್ ಟೈಮ್ 2 days ಅಲ್ಲಿ ಮಾಡಿ ನಂಬರ್ 1 and 2 ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿದ್ವಿ ಅದು ಅಕ್ಸೆಪ್ಟ್ ಆಗಿದೆ ಇಲ್ಲಿ ಮೆಮೊದಲ್ಲಿ ಕೂಡ ಅದನ್ನು ಕರೆಗೆ
for the appellant legally present and files a memo along with rectified certified copy of the judgment and award. BC 354 of the 2019, against which judgment and award the present appeal has been filed. Filing of the said memo with annexure, the Learned Council pays permission to carry out the necessary amendment to correct the name of the insurance company in respondent number 3. Alve, ಮಾಡ್ಬೇಕಲ್ವೇ?
In addition to that, I will amend the name of the court in the present appeal also. It is also a mistake.
ಅದನ್ನೇ ನಾನು ಕೇಳ್ತಾ ಇರೋದ್ರಿ.
Please.
Since the typographical error that was crept in the interim judgment and award in describing the details of respondent number 3 insurance company has now been rectified. The appellant is permitted to carry out the amendment correcting the name of with the correspondent insurance company during the course of the day.
What is
Tokyo.
what is right?
Respondent number 3, IFCO Tokyo General Insurance Company Limited.
Notice to respondent number 3. The appellant to pay the necessary process and furnish copies in the registry if not already done within 4 days from today. PCR.
Cell number 21, Sarita Kulkarni.
For number 1 is filing dispensation memo to R1 memo who is owner come driver.
India Insurance.
Respondent number 2, New India Insurance Company Limited.
Filed R1 dispensary with pay process 4 days for issue notice to R2. PCR. Yes.
Cell number 22, Girish SN. Respondent number 2, United India Insurance Company Limited.
ಇದು ನಿಮ್ಮ 5ನೇ ಮೆಮೊ ಮ್ಯಾಟರ್ಗಳನ್ನು ನೀವು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಫೈಲ್ ಮಾಡ್ತಾ ಇರೋದು ನನ್ನ ಮುಂದೆ ಈ ವಾರದಲ್ಲಿ 2 days. ಎಲ್ಲದರಲ್ಲಿಯೂ ನೀವು ವೈಟ್ನರ್ ಹಾಕಿ ಹೆಸರನ್ನು ಚೇಂಜ್ ಮಾಡಿದ್ದೀರಿ. ಅಷ್ಟೆಲ್ಲ ಲೇಬರ್ ತಗೊಳ್ಳೋದ್ರ ಬದಲು ನಿಮ್ಮ ಸಿಸ್ಟಮ್ನಲ್ಲಿ ಅದೊಂದು ಹೆಸರನ್ನ ಬದಲಾಯಿಸಬಹುದಲ್ವೇ? ಇದು ಚಂದ ಕಾಣುತ್ತೆ. ಸಣ್ಣ ವಿಷಯ. United India.
Respondent number 2, United India Insurance Company Limited.
Steps ತಗೊಳ್ಳಿ during the course of the day. R2. ತಗೊಂಡಿದ್ರಿ. Counsel for the appellant submits R1 dispensation ಆದ್ರ ಮೇಲೆ submits that he has taken steps for R2 in the registry today. Registry to verify and proceed further. Call for PCR.
Cell number 23, Girisha SN. KSRTC, sole respondent.
I will take notice, my lord, for KSRTC.
Counsel for appellant. Current Counsel Sri D. Vijay Kumar present. Current Counsel Sri D. Vijay Kumar accepts notice for respondent. Copy furnish ಮಾಡಿ. Current Counsel for the appellant is directed to furnish the copy of memorandum of appeal IA number 1/22 along with annexures if any to the said Current Counsel for respondent number 2 within 3 days from today. Current Counsel for respondent number 2 is granted 2 weeks time to file wakalat and objections if any to IA 1/20. In the meantime, call for TCR.
Much
Cell
obliged.
number 24, R Shashidhara.
Dispensation on 28 March 23.
Where you have filed?
Including the registry.
Counsel for the appellant submit that they has filed a memo seeking dispensation of notice to R1 in the registry. Registry to verify and call the matter at 2:30 p.m.
Hearing on interlocutory application serial number 25, Firoz Nizam A, KP Bhuvan, correspondent.
Additional. both the petitioner and respondent are present. Filing a memo. Earlier application. Filing under section 147.
Application was to file that application, they register. For the petitioner. The counsel from both sides present. Petitioner files a memo seeking withdrawal of the 1/23. In of the memo supporting submission, IA 1/23 stands. Disposed as withdrawn. You are free to file fresh application. Section 147 NIR as paid. Cards received. That's the ಏನಮ್ಮ ನಿಮ್ಮ ಹೆಸರು? ಯಾಕೆ ಬಂದಿದ್ದೀರಿ ಇವತ್ತು ಕೋರ್ಟಿಗೆ? ಎಷ್ಟು ದುಡ್ಡು ವಾಪಸ್ ತಗೊಂಡ್ರಿ ನೀವು? ಕೆಳಗಡೆ ಕೊಟ್ಟಲ್ಲ ಅವ್ರು ಏನ್ 1.5 ಲಕ್ಷ ರೂಪಾಯಿ ಇಟ್ಟಿದ್ದಾರೆ, ಅದನ್ನ ಅವ್ರಿಗೆ ವಾಪಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನಿಮ್ದೇನು ತಕರಾರು ಇಲ್ವಾ? ನಿಮಗ್ ಬರ್ಬೇಕಾಗಿರೋ ದುಡ್ಡು ಪೂರ್ತಿ ಬಂದಿದ್ಯಾ? ಅವ್ರನ್ನ ಬಿಡುಗಡೆ ಮಾಡ್ಲಿಕ್ಕೆ ನಿಮ್ದೇನ್ ತಕರಾರು ಇಲ್ವಾ? ಏನಪ್ಪಾ ನಿಮ್ ಹೆಸರು? ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ದೀರೇನಪ್ಪ? ಏನಂತ ಹೆದರಿಸಿದ್ರಿ ಅವರಿಗೆ? ಹೆದರಿಸ್ಲಿಲ್ಲ. ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಾಗಿರೋ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಿ? The summary of the case of the complainant, the trial court was that the accused, who was his relative, has borrowed a sum of ₹3 lakh for his family legal necessities. Agreeing to repay the said amount within the last week of August 2015. Towards the repayment of the loan, the accused had issued a check to her bearing number 216249 dated 31/8/2015 on a Citibank Bengaluru branch in her favor for a sum of ₹3 lakh. The said check, when presented for realization, returned unpaid, the reason of closure of the account of the drawer. Thereafter, the complainant got issued the accused a legal notice demanding the payment of the check amount. Since the accused did not comply the demand made in the notice, she was constrained to institute a complaint against the accused. The trial court, under section 130 for the offence punishable under section 138 of NI Act. ಇದೆಲ್ಲ ಹಾಕಿ parties have agreed that the parties have agreed that the complainant has stated the application, which is supported by an affidavit, supported by the joint affidavit of the parties, that the complainant has received the entire consideration from the prisoner of the accused pertaining to the bearing check number 216249 dated 31/8/2015, and she has no further claims whatsoever pertaining to the check as against the accused. It is further stated by her that she has no objection for refunding a sum of ₹1,52,000 check have been deposited by the accused bracket petitioner hearing for the trial court. CC number 28/2016. ಆಮೇಲೆ ಕರಡು ಫ್ರೀ ವೋಲಿಷನ್ ಅದೆಲ್ಲವೂ ಬರ್ತದೆ ಫಾರ್ಮೆಟ್. Accordingly, matter stands compromise. Department ಇದೆ ಹಾಕಿ trial court is directed to release some of ₹1,52,000 deposited, if any, by the accused before it in CC number 28/2016. The petitioner hearing the accused before the trial court in accordance with law and after due identification of the accused. The stands admitted. Yes, sign ಹಾಕಿ ಬಿಡುಗಡೆ ಆಗಿದ್ದೀರಿ. Credit cost is been deposited.
Serial number 26, Gurudev. 80.
Assurance company goes.
Field Assurance Company Limited.
Respondent. Both the respondents do serve have remained absent. Respondents have neither filed their objection. The respondents have not filed their objection in claim to A1 but 2021. The A1 bar 21 filed under section 5 of Limitation Act. Allowed delay condoned to 23 days. It is here.
Serial number 27, Gopal Krishna and Ravi Sampriti for respondent number 2.
No, condoned the allowed TCR. Yes.
Serial number 28, Pradeep B. Samir SN for respondent 4.
One more connected appeal is there. Arising same accident, different MVC.
Raising?
Same accident, but different MVC, MSC.
Not necessary to connect. It's also by claimant, right?
Please, Malak. No, Malak. Both of the appeals.
Insurance company.
Please, Malak.
Same accident.
Please, Malak.
Counsel for the appellant present.
MFA number 602. Division bench, Malak.
Connected with. That counsel for the appellant submits that beside MFE is before the division bench of this court. If so, registry to obtain necessary permission from the Honorable Chief Justice of this court and put this matter before the said division bench along with said MFA number. So.
Serial number 29, Manoj Kumar, K.S. Anita.
Then appearance the matter could not be proceeded. Mood matter.
29.
And appear in this matter, either physically or through video conference, even after getting the matter listed by moving a specific memo, the learned counsel for the appellant has remained absent. Thus, the appellant has not properly utilized the precious time of the court and deprived another eligible matter from being listed within the board. Accordingly, the matter stand adjourned. However, by imposing a cost of ₹500 payable by the appellant to the Legal Services Committee of this court within 2 days from today and filing a complaints memo along with version received to that effect in the registry in the said time. Any further posting of the matter is only after ensuring the payment of the cost ordered today and after bringing today's observation to the notice of the court. Yes.
Serial number 30, Rupesh D. Radha BP for respondent.
Yes.
I leave to.
Both side present no objection. Ajay allowed delay condoned TCR. Yes.
Still number 31, Yogesha GK, Janardhan Reddy for respondent number 1.
Both side present are to dispensable. Finally, 3 weeks time to file objection if any to IA 1/23. TCR. Yes.
Still number 32, Pramod Gowda TP. Respondent number 2, United India Insurance Company Limited.
Notice ಒಂದು ಡಿಸ್ಪೆನ್ಸ್ ಆಗ ನಾನು for appellant not present matter passed.
Still number 33, Ranganath Prasad. Still number 34, Harsha Kumar Gowda.
Liability is fixed on the respondent number 3 issues.
Second dispensation.
Will file the memo.
File a memo.
To my lord.
Insurance.
Respondent number 3, United India Insurance Company Limited.
R1 and 2 dispense with. Copy put every. I copy no put.
Sir, man.
10 days to file wakala. The objection to IA if any. TCR.
Seal number 35, Avinash P.
For weeks time, maybe handle
The submission of 11 counsel for the opinion. There is the memorandum of appeal and the impugn judgment. Issue notice to the respondents, national insurance.
Action.
Counsel.
I will take another. Yeah,
For R1 or a copy kudi. Yedo copy kudi. Auto steps the registry 3 days. 10 days to wakalat and objection by R1. If steps to R1 or R2 is not taken in the registry, it's a matter on 11. TCR.
Seal number 36, Satish Ati.
Sorry. Issue notice memo R1 dispense with ICICI Lombard.
Respondent number 2, ICICI Lombard Limited.
Decision Goda.
Payment application. MF number 7200/2020. Method.
Copy kudi. 10 days wakalat objection. Counsel for the opponent submits that arising out of the same accident, one more MFA bearing number so and so is also pending before the registry and press to connect it terminal register to verify do need.
Seal number
Yes.
37.
TCR.
Seal number 37, Kailash Shankar.
Second.
Why have not filed wakalat as it?
For the week's time, I will get it. I have informed the company that they are not extended.
From both sides presented the request of the counsel for respondent number 2 as finally a week's time is granted to file wakalat and objections if any to A1 bar.
Seal number 38, Shankar Gaudji. Raju S for respondent.
Even also file an appeal. The position was not taken on 22. What a language.
On the ground of negligence and responsibility. Negligence is on the timing response. Planning the works on the doing in the NH code
You are for appellant. Huh.
days filing
Copy of the appeal memo is not
Yeah.
You have filed one more appeal. Huh?
claimants.
You have filed one more appeal. Direct counsel from both sides present. Also, I submit that against the same influence judgment and award one more appeal bearing MF number so and so is also filed and pending. You want to connect that appeal with this? ಯಾವ್ದ್ರಲ್ಲಿ ಇದರಲ್ಲಿ ಅದರಲ್ಲಿಯ ಹಾ ಹಾ ಅದ್ಯಾವ್ದು ಅಯ್ಯ ಕೊಟ್ರಿ ಅದು
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಇದಕ್ಕೆ.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
ಕಾಪಿ ಮಾತ್ರ
ಒಂದ್ ನಿಮಿಷ. There is a delay. You have not furnished him the copy. Furnish him the copy first. ಈಗೊಂದು ಕೊಡಿ. ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಹೇಳ್ತಾರೆ. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಹತ್ರ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅವ್ರಿಗೊಂದು ಇಂಡಿಯನ್ ಕಾಫಿ ವ್ಯಾನ್ ಒಂದು ಕಾಫಿ ಕುಡಿಸಿ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತಾರೆ. ಅದಕ್ಕೆ ರೀ ಟೈಮ್ ಇದೆ. ಇವತ್ತೇ ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಮಾಡಿ ಎಂದಿದ್ದು. ಹೋಗ್ರಿ ಪುರ್ಸತ್ ಮಾಡ್ಕೊಂಡು. ಕಾಪಿ ಕೊಡಿ. ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಹಾಕ್ಬೇಕು. ಡಿಲೇ ಇದೆ. ಡಿಲೇ ಇದ್ದಾಗ ನೀವು ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ವಾರೆಂಟ್ ತಗೊಂಡು ಬಂದಿದ್ದಾರೆ ಅಂತ ಇಲ್ಲಿ ಬಂದು ಹೋ ಅಂದ್ರೆ ಆಗಲ್ಲ. ಅಲ್ಲಿವರೆಗೆ ನಿದ್ದೆ ಮಾಡಿ ಕಡೆ ಮೂಮೆಂಟ್ ಅಲ್ಲಿ ಎದ್ದು ಬರ್ತೇನೆ ಸ್ವಾಮಿ ನಾನು 100% ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೇನೆ ನನಗೆ ಸ್ಟೇ ಕೊಡಿ, ಕೊಡಲ್ಲ. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲೇ ಕೊಡಿ, ಅದೇ 100% ಕೊಡಿ. ಅವ್ರಿಗೆ ದುಡ್ಡು ಬರ್ತದೆ. ಅವ್ರಿಗೆ ರಿಲೀಸ್ ಆಫ್ ದಿ ಅಮೌಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು ಬೇಡ. ಅವ್ರು ಮತ್ತೆ ನಿಮ್ಮ ತಂಟೆಗೆ ಬರಲ್ಲ. ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಫಾಲೋ ಮಾಡ್ತಾರೆ. 163 days ಡಿಲೇ ಇದೆ. ಅವ್ರಿಗೆ ಇದು ಕೊಡಿ, ಅಪ್ಲಿಕೇಶನ್ ಕಾಪೀಸ್ ಕೊಡಿ. ಏನ್ ತಗೊಂಡ್ರಿ?
Judgment and award one more appeal is pending in misunderstanding is also filed and registry to
registry to work. The learned counsel for the respondent submits that the copies of A1/23 has not been furnished to him. As such, he prays some time to file his objection, if any, after receipt of the copy of A1/23. The copy right now ಅವ್ರಿಗೆ ಕೊಟ್ರೆ ನಾನು ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಬಹುದು. ಇಲ್ಲದೆ ಹೋದ್ರೆ ನಾನು ಕಂಡೀಷನಲ್ ಆರ್ಡರ್ ಮಾಡಬೇಕಾಗ್ತದೆ. ಹೌದ್ರಿ, ಈಗ ನೀವು ಕೊಟ್ಬಿಟ್ರೆ ಕಾಪಿ ಸರ್ವ್ಡ್ ಅಂತ ಮಾಡ್ತೇನೆ. ಅವರಿಗೆ 3 days ಟೈಮ್ ಕೊಟ್ಟು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ ಅಂತ ನಾನು ಡೇಟ್ ಕೊಟ್ಬಿಡ್ತೇನೆ. ಇಲ್ಲದೆ ಹೋದ್ರೆ ಹಿ ಗೆಟ್ಸ್ 1 week ಟೈಮ್ ಆಫ್ಟರ್ ರಿಸೀಟ್ ಆಫ್ ದಿ ಕಾಪಿ ಆಫ್ ದಿ ಎ. ಆಮೇಲೆ ಅವ್ರು ಬಂದು ಸ್ವಾಮಿ ನಂಗೆ ಕಾಪಿನೇ ಕೊಡ್ಲಿಲ್ಲ ಅಂತಾರೆ. 1 ವಾರ ನಿಮ್ ಕಣ್ಣಿಗೆ ಬೀಳಲ್ಲ ಅವರು. ಅಯ್ಯೋ ಕಥೆಯ ಬೆಂಗಳೂರು ವಕೀಲರು ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? The respondent is granted a week's time to file his objection, if any, to IA1/23 after receipt of the copy of IA1/23. Yes.
Still number 39, Archana KM.
1/22 and 1/23.
Still number 39, Archana KM.
Was there any violation of the policy?
No, my lord.
Learned counsel from the Legal Services Committee for the appellant is physically present. Her submission on main appeal and on IA 1 and 2 of 2023. Issue emergent notice to the respondents. United India Insurance.
Respondent number 2, United India Insurance Company Limited.
Emergent notice to the respondents both on the main appeal and on pending IAs. Is the matter wrong? Seventeen. 4.
One submission, will be permitted to amend the cost title of the address, so in the consider. Appellant address name.
Yes, without any say the request in writing in a manner known to law, you cannot see.
Till number 40, Uttar Padmavati Suresh.
TCR of a cable.
I represent the appellant in this case. It's an insurer appeal. Quantum. Tribunal has awarded a sum of 4 lakhs global compensation. Though there is no doctor examined in this case, but the disability certificate only is produced. He is not been subjected for cross-examination. That notes in page 15, para 17, notes is the finding of the tribunal.
The submission of learned counsel for the appellant. On the main appeal and propose the appeal, memorandum of appeals, informed order and IAS. It's delay in filing the appeal. It can issue emergent notice to the respondents both on the main appeal and on IA. Appellant to pay the necessary process and furnish copies in the registry within a day from today, if not already been done, within a day from today. List the matter immediately after. It's of notice of approval.
I will file the necessary application, necessary memo notes in the registry. Because the appellant got notes in not in the station, but seeking dispensation notes to respond number 2. Permit because it's only on quantum.
The matter on 74. Memo high caste ಒಳಗೆ steps R1 ಗೆ ಮಾತ್ರ ತಗೊಳ್ಳಿ.
Yes.
Till number 41, Rangegowda NR.
TCR.
Of the counsel for the appellant. If of this, the delay of 42 days in filing the appeal.
Seeking dispensation.
R1 and R3.
File a memo. Issue notice R1, R3. Dispense with Royal Sundram.
Respondent number 2, Royal Sundram, General Justice Company Limited.
These steps. PCR. R2 steps thoroughly register within 4 days.
Serial number 42, Hirematat Maheshaya Rudraya.
Dude was a minor. Bajaj Alliance.
I will take notice for that.
Respondent to Bajaj Alliance.
R1, R3. No, kindly dispense with. But issue notice bರ್ತದೆ. Counsel Sri D. Vijay Kumar. Case notice for respondent number 2, insurance company. The appellant to furnish. The counsel for respondent number 2, the copy of the memorandum of appeal and IA 1/23 along with annexures if any within 4 days from today. The counsel for respondent number 2 is granted 2 weeks time to file wakalat and objections if any to IA 1/2023. In the meantime, call for TCR.
Please, Lord.
Yes.
Serial number 43.
ಇದು ಮೊದಲನೇ ಹುಡುಗನ ಅಕ್ಕನ ಅಪ್ಪನ ಕೇಸ್ ಇಲ್ಲ ಬೇರೆದಿದೆ. Bajaj Alliance.
Respondent number 2, Bajaj Alliance, General
I
Justice
will
Company
take
Limited.
notice. I will take
Same.
notice. Connected.
Same order. Copy ಕೊಡಿ. Same order.
Serial number 44, N. Krishnaswamy.
Issue notice steps within a week. TCR.
Still number 45, HP Rudresh.
Notice on main and as well on IE. Notice on the other first list and IE will other to say so.
The data of Pakistan that the insurance policy is valid. Yes, but insurance company also admitted the insurance policy in their written statement. When there is a 15 days delay, attachment of removal warrant has been issued.
ಇಲ್ಲ ಒಳ್ಳೆ ಕಾಸ್ಟ್ಲಿ ವ್ಯಾಲ್ಯೂಬಲ್ಸ್ ಒಳಗಡೆ ಇಟ್ಕೊಳ್ಳಿ, ಬ್ಯಾಡದೇ ಇರೋದು ಮುರಿದೋಗಿರೋ ಕುರ್ಚಿ ಟೇಬಲ್ ಸ್ಟೂಲು ಹೊರಗಡೆ ಇಡಿ, ನೋಡಿ ಹಾಗೆ ವಾಪಸ್ ಹೋಗ್ತಾರೆ, ಅಟ್ಯಾಚ್ ಮಾಡಲ್ಲ.
15 days delay. Date of Pakistan.
Why the insurer was not held liable?
So vehicle. Rider of the offending motor vehicle having heavy motor vehicle DL. Having
no paid recovery order was made. No order was made.
Yes, for paid recovery. Insurance company, insurance company also admitted the insurance policy. Page 19. Admit for options. Respondent admitted the issuance of insurance policy, its validity in respect of the physical access scooter bearing registration number shown on the date of the alleged accident, but further submits that the rider of the motorcycle registration number A45X4553, which belongs to the petitioner, riding their respective vehicles without holding valid driving license, without wearing gears at the time of accident.
Because the claimant has preferred any appeal. For the submission of legal counsel for the appellant, there is the memorandum of appeal in the tuned order. It's a delay of 15 days in filing the appeal. Issue emergent notice to the respondents both on the appeal and on IA for 2023. Appellant to pay the necessary process and for copies in the registry, if not already made, within a day from today. Just the matter on 17/4. Yes, please. ಆಗುತ್ತೆ, ನೀವು ಆರ್ಡರ್ ಆದ ಕೂಡಲೇ ಬರ್ಬೇಕಿಲ್ಲಿ. ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಲ್ಲಿವರೆಗೂ ಸುಮ್ಮನೆ ಇದ್ದು ಆಮೇಲೆ ಬಂದ್ರೆ ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. ಮಿಸ್ಪ್ಲೇಸ್ ಕಾಪಿ ಇಸ್ ನಾಟ್ ಇನ್ ಎಕ್ಸ್ಕ್ಯೂಸ್ ಸರ್, ಅಲ್ವೇ? ಸ್ವಯಂಕೃತ ಅಪರಾಧಗಳು. ಅದನ್ನ ನೀವು ವಕೀಲರು ಹೇಳ್ಬಾರ್ದು. ಕಾಪಿ ಮಿಸ್ಪ್ಲೇಸ್ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರೆ, ಅಯ್ಯ ಅದು ನೀನ್ ಮಾಡಿದ್ರೆ ನಾನ್ ನಿನಗೆ ಬೈಬಲ್ಲೆ, ಅದನ್ನ ನಾನು ತಗೊಂಡೋಗಿ ಕೋರ್ಟಿಗೆ ಹೇಳಿದ್ರೆ ನನ್ ಮೇಲೆ ನಾಗಾಡತ್ತೆ, ಏನ್ ವಕೀಲ್ರಿ ನೀವು, ಅವನ್ನೆಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಗ್ರೌಂಡ್ ಆಗಿ ಹೇಳ್ತಾರೇನ್ರಿ ಅಂತ ಹೇಳ್ಬೇಕು, ಅಲ್ವೇ? ಅದು ಸ್ವಯಂಕೃತ ಅಪರಾಧ. ಸ್ವಯಂ ನಿರ್ಲಕ್ಷ್ಯತನಕ್ಕೆ ಪರಿಹಾರವಿಲ್ಲ, ಅಲ್ವೇ? ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ನಿಮಗೆ ಅವ್ರಿಗೆ ಫಾರ್ಮ್ಯಾಟ್ ಹೇಳಲಿಲ್ಲ, ನಾನು ಡಿಕ್ಟೇಷನ್ ಕೊಡಿಸಿದೆ. ನೀವೇನಾದ್ರೂ ಅಡಿಷನಲ್ 1 ಸೆಂಟೆನ್ಸ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀರಾ ಅಂತ ಎಕ್ಸ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಸ್ಟೇ ನೀವು ಮಾಡ್ಲಿಲ್ಲ. ಮಾಡಿದ್ರೆ ಕೊಡೋಣ ಅಂತ ಇದ್ದೆ, ನೀವು ಮಾಡ್ಲಿಲ್ಲ. ನಾನೇನ್ ಮಾಡ್ಲಿ? ನಾನು ಹೇಳಿಕೊಟ್ಟು ಬರೆಸಲಿಕ್ಕೆ ಬರೋಲ್ಲ, ಅದು ನೀವು ತಿಳಿದು ಮಾಡ್ಬೇಕು. ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ, ಬನ್ನಿ. ಏನಾದ್ರು ನೀವೇನಾದ್ರು ಮಾಡಿದ್ರೆ ಮಾಡ್ತಿದ್ದೆ, ಇಲ್ಲ ಸ್ಟೇ ಕೊಡುವ ಪ್ರಶ್ನೆಯೇ ಇಲ್ಲ. ಇರಬಹುದು ವಕೀಲ್ರೆ, ಹಾಗಾಗಿಯೇ ಈಗ ನಾನು ಡೆಪಾಸಿಟ್ ಅಂತೀರ, ಅನ್ನೆಸೆಸರಿ ಯಾಕೆ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಿ? ಅವ್ರು ಬರ್ಲಿ, ನಿಮಗೆ ವಿತೌಟ್ ಎನಿ ಅಮೌಂಟ್ ನಿಮಗೆ ಇಂಟೀರಿಯಂ ಸ್ಟೇ ಸಿಗದಾದ್ರೆ ಯಾಕೆ ವೈ ಡೋಂಟ್ ಯು ಲೂಸ್ ದಟ್ ಆಪರ್ಚುನಿಟಿ?
46 HP
17-4.
14-4.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಅಷ್ಟೊಳಗೆ ಹೋಗಿ ಬರೋಲ್ಲ. ನಾವು 14-4 ಕೊಡಬಲ್ಲೆ, ಅವ್ರು ಅವೈಟ್ ಅಂತ ಹಾಕ್ತಾರೆ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗುತ್ತೆ.
ಪೇಪರ್ ಶೀಟ್
ಕೊಡಿ ಅಂದ್ರೆ ಕೊಡ್ತೇನೆ ನಾನು, ನನಗೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ಬರ್ಕೊಳ್ರಿ 14-4. ನಾನು ಏನೇ ಒಂದು ಡೇಟು ಏನೋ ಒಂದು ಹೇಳಿದ್ರೆ ಎಲ್ಲಾ ಆಂಗಲ್ ಅಲ್ಲೂ ಆಲೋಚನೆ ಮಾಡ್ತೇನೆ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Number 46 HP Rudresh.
Similar. Same assistant. Common technical.
Same order. Next.
Serial number 47 Ashok N Patil.
74. MTCRO.
Rising minutes out of the
1 ನಿಮಿಷ ಹಿಂದಿದ್ದು ಕೊಡಿ. ರುದ್ರೇಶ್.
HP Rudresh.
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಗೆ ನಿಮಗೆ ಸರ್ವ್ ಮಾಡೋದು ಬೇಡವೇನ್ರಿ ವಕೀಲರಿ ಇದ್ರೆ? ನಾಳೆ ಅವ್ರಿಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಗೆ ನೋಟಿಸ್ ಅಂತ ಆರ್ಡರ್ ಆದ್ರೆ ಆಮೇಲೆ ಅವ್ರಿದ್ದವ್ರು ನಮಗೆ ನೋಟಿಸ್ ಹೋಗ್ಲಿಲ್ಲ ಅಂತಾರೆ, ವಕಾಲತ್ ಹಾಕಲ್ಲ. ಕೇಳ್ಬೇಕಲ್ವ ನೀವು ಅದನ್ನು? ಬಜಾಜ್ ಅಲೈನ್ಸ್ ಕೂಗಿಸ್ರಿ.
Respondent number 3 Bajaj Alliance General Insurance Company Limited.
ನೀವು ತಗೊಳ್ತೀರಿ, ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆ, ಎರಡು ಕೈಲಿ ಕೊಟ್ಬಿಡಿ. ಜೊತೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅವರಿಗೆ ಮಧ್ಯಾಹ್ನ ಲಂಚ್ ಕೊಡಿಸಿ ಕಾಪಿ ವಾಪಸ್ ಕೊಡಿ. ಇನ್ಶೂರೆನ್ಸ್ ಶ್ರೀಮಂತ ಕಂಪನಿ ಮಾಡಬಹುದು. ಎರಡರಲ್ಲಿಯೂ R3 current counsel Shri So Pradeep takes notice for respondent number 3 and acknowledges the ಎರಡರದ್ದು ಕೊಡಿರ್ಬೇಕು ಕಾಪಿ. Acknowledges the receipt of the copy of the memorandum of appeal with the IA. R3 is granted 2 weeks time to file wakalat and objection if any to pending IAs.
47 Ashok N Patil.
Delay of 26 days. Is 500. File a memo. Challenging contributor negligence attribute at 50% each on not on 2 insurers. Traveler notes came and notes hit from the inside. Notes I was my vehicle not proceeding on the.
You are the insurance company, right?
Yes, not. There are 2 insurance company notes in this case.
Probably you are the richer and reliable.
50-50 ಮಾಡಿದ್ದಾರೆ sir. Now what is happened is
you are unhappy. We'll
Yes.
make it 100.
Yes.
To you.
No, I am seeking notes on the other offending right.
Notice. So Liberty General Insurance.
Respondent number 5 Liberty General Insurance Company Limited.
Notes from Liberty notes Mr. P. Sampathya side appeal.
Has filed an appeal.
Have also.
You have its number. I'll pass over the matter.
I will find out.
Pass on the number to the court officer. If so, we will order for connecting
Yes.
so that you can save the cost of the service of notice. Matter is passed over at the request of the council for that.
Serial number 48 Srinivasan MY.
In this case.
There are 3 cases arising out of same accident. 2 cases, the case of injury, and 1 malad, the death of malad child in the home malad. This petition malad arising out of MEC 89 of 2018. This petition was dismissed, not maintainable.
Why not maintainable?
The appellant cannot seek compensation of the courtess or child in the womb ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದನ್ನ ಕೇಳಕ್ ಬರೋದಿಲ್ಲ, ಇನ್ನು ಅದು ಈಚೆ ಬಂದಿರಲಿಲ್ಲ. ಸೊ ಹಾಗಾಗಿ ಅದನ್ನ ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ. ಅದರ್ ಕೇಸಸ್ ನಲ್ಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಈ ಕೇಸ್ ನಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್.
ಕನೆಕ್ಟೆಡ್ MFAಗಳು ಇದೆಯಾ ಇದರಲ್ಲಿ?
ಮಾಡಿದೀನಿ. ಅದೇನಂತಂದ್ರೆ ಅದರಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್ ಹಾಕಿಲ್ಲ, ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ ಇದೆ.
ಇದನ್ನ ಕ್ಲಬ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಯಾವಾಗ ಅದಕ್ಕೆ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೊಡ್ತಾರಲ್ಲ,
ಮಾಡಿ
ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳಿದ್ರ ಜೊತೆಗೆ ಕ್ಲಬ್ ಮಾಡಿ. MFA ನಂಬರ್ ಇದೆ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ appellant. How old was the embryo?
4.
Fetus age?
Fetus age 6 months.
6 months.
Yes, ma'am. So several decision is 2,50,000 has been granted in the decision of KSRTC versus Vidya Shinde, reported in 2005 ACJ 69.
For the submission of learned counsel for the appellant who is physically present in order of appeal, if in the order, issue emergency notice to the respondents. Learned counsel for the appellant files. ಇದರಲ್ಲಿ ನೀವು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಬೇಡ,
ಯಾಕೆಂದ್ರೆ ಫೈಂಡಿಂಗ್ 26 ನಲ್ಲಿ ಸೊ ಟ್ರಿಬ್ಯುನಲ್ come to conclusion the pending vehicle the insurance company is liable to pay the compensation ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ. So other 2 cases ಇದರಲ್ಲಿ announcement order ಆದ್ರೆ so naturally
ಇದರಲ್ಲಿ ನಿಮಗೆ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಇದರಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗ್ತಿದೆ
ಅಲ್ವಾ? ಇದರಲ್ಲಿ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆದ್ರೆ ಅಂತಿದ್ದೀರಿ, ಇದರಲ್ಲಿ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಕ್ವಶನ್ ಬೇಸಿಕಲಿ ನಿಮ್ಗೆ ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ಹಾಗಾಗಿ ಬೇಡ ವಾಪಸ್. New India Assurance.
That's one number 2. New India Assurance Company Limited.
The respondents. Appellant to pay the necessary process and furnish copies in the registry, if not already done within a week from today.
Please.
Learned counsel for the appellant submits that arising out of the same common judgment and award 2 more MFS bearing number so filed and placed to with all the 3 appeals together. New India ki nee vilvenri chune kodre kodalva idರಲ್ಲಿ ಮೂರು ಮ್ಯಾಟರ್ ಒಟ್ಟಿಗೆ ಬರ್ತದೆ, ಅದಕ್ಕೆ ಹೇಳಿ ಅದೊಂದು ಇರ್ತದೆ ಕೆಲವು ಇನ್ಶೂರೆನ್ಸ್ ಅದೇ ನಿಜ. ಅಟ್ಲೀಸ್ಟ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರು ಅವ್ರಿಗೆ ಬೇಕಾಗಿರೋ ಪ್ಯಾನಲ್ ಅಡ್ವೊಕೇಟ್ಗಳದ್ದೊಂದು ನೇಮ್ಗಳನ್ನ ಕೊಟ್ಟು, ಸ್ವಾಮಿ ರೊಟೇಷನ್ ಅಲ್ಲಿ ನೀವು ಕೊಡ್ತಾ ಬರ್ರಿ, ಈ 5 ಜನರು ವಕೀಲರಿಗೂ ತಲಾ 2 ಕೊಡ್ತಾ ಬನ್ನಿ, 10 ಆದ್ಮೇಲೆ 11 ಮತ್ತೆ ಇಂಥವ್ರಿಂದ ಶುರು ಮಾಡಿ ಅಂತ ಏನಾರು ಹೇಳಿದ್ರಾದ್ರೂ ನಾವು ಮಾಡ್ಬೋದು. ಅವಾಗ ದೇ ಆರ್ ಬೌಂಡ್ ಟು ಗಿವ್. ಹೌದು, ಹೌದು, ಯು ಕಾಂಟ್. ಅಲ್ಲ, ಇಲ್ಲಿ LIC ಸಂಬಂಧಪಟ್ಟವ್ರಾದ್ರೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಕೂರಿಸಿ ಒಂದ್ಸರ್ತಿ ಸ್ವಲ್ಪ ಸ್ಟ್ರಾಂಗ್ ಆಗಿ ಮಾತಾಡ್ಸಿ ಸಾಹೇಬ್ರ ಹತ್ರ. Let's say unnecessarily the insurance companies also cannot cause inconvenience to counsel on panel. Every day you cannot visit their office. At least notice ಒಂದು ಸ್ಟ್ರೀಮ್ಲೈನ್ ಆಗಿಬಿಟ್ರೆ ಬೇಡ, ಒಬ್ಬರೇ ವಕೀಲರಿಗೆ ಜಾಸ್ತಿ ಅಕ್ಯುಮುಲೇಟ್ ಆಗೋದು ಬೇಡ, ಒಪ್ಪುವ. ಆದ್ರೆ ಅವರೇ ಚೂಸ್ ಮಾಡಿ ಕೊಟ್ರೆ ನಮಗೆ ಇಂತಿಂತ ವಕೀಲರು, ನಮಗೆ 12 ಜನಗಳಲ್ಲಿ ಈ 8 ಜನರು ನಮಗೆ ಎಕ್ಸಲೆಂಟ್ ಸರ್ವಿಸ್ ಕೊಡ್ತಾರೆ ಸರ್, ಈ 8 ಜನಗಳಿಗೆ ನೀವು ಹೀಗೆ ಕೊಡಿ ಮಾಡ್ಬೋದು. ಇದು ಅಥವಾ ಇಂಥ ಬ್ರಾಂಚ್ ಇವರಿಗೆ ಕೊಡಿ, ಓಕೆ ವಿ ಕ್ಯಾನ್ ಡೈರೆಕ್ಟ್ ಟು ಅವರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಅಟ್ಲೀಸ್ಟ್ ಇಂತಿಂಥ ಬ್ರಾಂಚ್ಗಳಿಗೆ ಇವ್ರದ್ದು ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿಡ್ರಪ್ಪ ಅಂತ.
Lord's meeting will convey it to the company.
ಅಯ್ಯೋ ಹೇಳಿ ಸಾಕಾಗಿದೆ ರೀ. ಅವ್ರಿಗೆ ಶಂಕದಿಂದ ಬಿದ್ರೆ ತೀರ್ಥ. ನಾನು ಬೀಜ ಇದ್ದಾಗ ಮಾಡಿದ್ದೇನೆ. ಇಲ್ಲಿದ್ದಾಗಲೂ ಕೂಡ ಧಾರವಾಡ ಬೆಂಚ್ ನಲ್ಲಿ ಹೋದಾಗ ಮಾಡಿದ್ದೆ. ಅಲ್ಲಿ 2 ನಲ್ಲಿ ಬೆಂಚ್ ಹೆಡ್ ಮಾಡಿದಾಗ ಎಷ್ಟು ಸ್ಟ್ರೀಮ್ಲೈನ್ ಆಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ, ಅಲ್ಲಿ MVC ಕೇಸ್ಗಳು ಮ್ಯಾಕ್ಸಿಮಮ್ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಆನ್ ಮೆರಿಟ್ ಕೋರ್ಟಿನಲ್ಲಿ. ನೋಟಿಸ್ಗಳು ಒಂದು ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ, ಇಶ್ಯೂರೆನ್ಸ್ ಆಫ್ ನೋಟಿಸ್ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ, ಎಲ್ಲ ನೋಟಿಸ್ಗಳು ಕಂಪ್ಲೀಟೆಡ್ ಸರ್ವ್ಡ್. ಸ್ವಲ್ಪ ಸ್ಟಾಫ್ ಗಳನ್ನ ಮೋಟಿವೇಟ್ ಮಾಡಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ವಕೀಲರನ್ನ ಕರೆಸಿ ಈಗ ಮಾಡಿದಾಗ ಮುಗಿದೋಯ್ತು. ಮಾಡ್ಬೇಕಾಗಿದೆ ಹೋದ್ರೆ
ರೀಜನಲ್ ಆಫೀಸ್ ಮೊದಲು ಆಗಿತ್ತು. ಸೂರ್ಯನಾರಾಯಣ ರಾಯರ್ಗೆ ನನಗೆ ಆಥರೈಸ್ ಮಾಡಿದ್ರು ನೋಟಿಸ್ ತಗೊಳಕ್ಕೆ ಎಲ್ಲಾದ್ರಲ್ಲೂ. ಆಮೇಲೆ ಅಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸೇಷನ್ಗಳು ಬದಲಾದಾಗ ಅವ್ರದ ಹೈದರಾಬಾದ್ ಅಲ್ಲಿ ಹೀಗ್ ಮಾಡ್ತಿದ್ವಿ, ಚೆನ್ನೈಯಲ್ಲಿ ಹಾಗೆ ಮಾಡ್ತಿದ್ವಿ ಅಂತ. ಇದು ಯಾವ್ದೋ ಒಂದು ಮ್ಯಾಟರ್ ತಾವೀಗ ನೋಟಿಸ್ ಮಾಡೋದಿದ್ರೆ ನಾನು ಐ ವಿಲ್ ಟೇಕ್ ನೋಟಿಸ್ ಅಂಡ್ ಐ ವಿಲ್ ಕನ್ವೇ ಇಟ್ ಟು ದೆಮ್. ದಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಸಜೆಸ್ಟೆಡ್ ದಿಸ್ ಈಸ್ ಮೋರ್ ಪ್ರಾಕ್ಟಿಕಲ್, ದಿಸ್ ಕ್ಯಾನ್ ಬಿ ಕನ್ಸಿಡರ್ಡ್ ಅಂತ ಹೇಳಿ ನಾನು ಐ ವಿಲ್ ರೈಟ್ ಟು ದೆಮ್.
ಅಲ್ಲಿ ಒಬ್ಬೊಬ್ರು ರೀಜನಲ್ ಮ್ಯಾನೇಜರ್ ಬಂದಾಗ ಅವ್ರ ವ್ಯೂಗಳು ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಹೈದರಾಬಾದ್ ಅಲ್ಲಿ
ಕನೆಕ್ಟೆಡ್ ಬರ್ತದೆ, ಕನೆಕ್ಟೆಡ್ ಬಂದ್ರ ಮೇಲೆ ಅದ್ರಲ್ಲೊಂದು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಹಾಕಿರ್ರಿ, ಇದ್ರಲ್ಲಿ ಒರಿಜಿನಲ್ ಇದೆ ಅಂತ ಬರ್ತದೆ. ಉಳ್ದಂತೆ ಈಗ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳೋದು. ಸ್ಟೆಪ್ಸ್ ಸರ್ವ್ ಆಗಿ ಬಂತು ಅಂತಾರೆ, ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಆಟೋಮೆಟಿಕ್ಲಿ ದ ಸೇಮ್ ಕೌನ್ಸಿಲ್ ವುಡ್ ಟೇಕ್ ನೋಟಿಸ್. ಯು ಕ್ಯಾನ್ ಸೇವ್ ಲಾಟ್ ಆಫ್ ಮನಿ, ಟೈಮ್, ಸ್ಟ್ರೈನ್, ಎಕ್ಸೆಟ್ರಾ. TCR, yes.
Still number 49, Girish B. Baladare.
Seeking enhancement of injury in the lordship.
Second dispensation to 2-3.
Yes,
What do you memo?
filed in counter senior station.
Counsel for the appellant present and place for 2 days accommodation, stating that they intend to file memo seeking dispensation of notice to respondent number 2 and 3. It's a matter on 31-3. Nadidu tondra illa.
Admission matter still number 50, Pawan Chandra Shetty H. N. Krishna Swami for respondent number 2.
For the second matter. It's correct. Not taken paper application draft. No application was allowed. My apology. He issued with some kind of
Memo won't do.
I will make the necessary application.
Yes. Yes. Learned counsel for the appellant in MFA 350/2017. Learned counsels for the appellants in both the matter are physically present. At the request of learned counsel for the appellant in MFA 350/2017, 4 days time as previous grant. What is now 1 week madidi? Connected matter?
Two person also filed in petition. First man. He may be taken.
Second put. ಸರ್ವ್ ಆಗಿದೆ. ಸರ್ವ್ ಆಗಿರೋದ್ರಿಂದ ಈಗ ಅದು ಅವ್ರ ತಲೆನೋವು. ನೀವೀಗ ತಣ್ಣಗೆ ನಿದ್ದೆ ಮಾಡ್ಬೋದು. ಅವ್ರ ವಕಾಲತ್ ಹಾಕ್ಬೇಕು. ಅವ್ರ ವಕಾಲತ್ ಹಾಕ್ತೆ ನಾಳೆ ನನಗೇನು ಗೊತ್ತಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳಲಿಕ್ಕೆ ಆಗೋಲ್ಲ. Now you are at more ease because respondent number 1 is already served.
Still number 51, Sitaram Rao, BC, Chetan B, for respondent number 1, connected.
Lord, I am for the appellate.
PCR on emergency.
PCR is received.
Yes. You can give it to
Chetan B,
Lord, I am the appellate in MFA 6292 of 2017. It is an appeal by the insurer.
Yes.
But the first respondent has suffered injuries on 2/4/2014.
1 minute. 1 minute. According to you, you were going along with your brother, right? Both of you injured or only you alone?
Oh,
Only one.
One was injured.
Yes, Mr. Counsel, proceed please. Insurance
That's-
company.
Kindly take to exhibit P3 the medical record produced by the claimant. RTA ಅಲ್ಲ, ವರ್ಕ್ ಪ್ಲೇಸ್ ಇಂಜುರಿ. ಇವ್ರು ಯಾವುದೋ ಬೋರ್ವೆಲ್ ರಿಪೇರಿಗೆ ಏನೋ ಪೈಪ್ ಎತ್ತಕ್ಕೆ ಹೋಗಿ ಪೈಪ್ ಎತ್ತಿದ್ದಾಗ ಬ್ಯಾಲೆನ್ಸ್ ತಪ್ಪಿ ತನ್ನ ಮೇಲೆ ಬಿದ್ದಿದೆ ಅಂತ ಕಾಣುತ್ತೆ. ವರ್ಕ್ ಪ್ಲೇಸ್ ಇಂಜುರಿ, ಅಲೀಜ್ ಹಿಸ್ಟ್ರಿ ಆಫ್ ಟ್ರಾಮಾ ಬೈ ಎ ಪೈಪ್ ವೈಲ್ ವರ್ಕಿಂಗ್ ಅಟ್ ಎ ಬೋರ್ವೆಲ್, sustained trauma to head, face and chest. The probabilities and the cause of injury may be ಈ ಪೈಪ್ ಮೇಲೆ ಎತ್ತಬೇಕಾದ್ರೆ ಬೋರ್ವೆಲ್ ಕೆಟ್ಟೋಗಿದ್ದಾಗಲೋ ಕೇಬಲ್ ಕಟ್ ಆಗಿದ್ದಾಗಲೋ ತೆಗೆದಾಗ ಬ್ಯಾಲೆನ್ಸ್ ತಪ್ಪಿ ಮಕ್ಕದ ಮೇಲೆ ತಲೆ ಮೇಲೆ ಬಿದ್ದಿದೆ ಅಂತ ಅನ್ಸತ್ತೆ. ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ಎನಿ ವೆಹಿಕಲ್ is not mentioned. Brother who lodged the complaint thereafter introduces a lorry carrying the rig. The manner of the accident explained would certainly leave lot of gaps. Probabilize agalla adu. Exhibit P2 is the complaint. May I trouble my lords to read the complaint lodged by the brother of the injured. Could my lords get that?
Yes.
ದಿನಾಂಕ 2/4/2014 ಸಂಜೆ 6:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು ಮತ್ತು ನನ್ನ ತಮ್ಮ ಮೋಹನ್ ಎಂಬುವರ ಸಂಗಡ ಜಮೀನಿಗೆ ನೀರು ಹಾಯಿಸಲು ಹೋಗಿದ್ದು, ಜಮೀನಿನಲ್ಲಿ ನೀರು ಬಿಟ್ಟು ವಾಪಸ್ ಮನೆಗೆ ಬರುತ್ತಿರುವಾಗ ನಮ್ಮ ಊರ ಹತ್ತಿರವಿರುವ ಕ್ರಾಸಿನಲ್ಲಿ ದಿನಾಂಕ 3/4/2014 ಬೆಳಗಿನ ಜಾವ 2:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಕರಡೇವು ಗ್ರಾಮದ ಕಡೆ ರಸ್ತೆಯ ಎಡಭಾಗದಲ್ಲಿ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿರುವಾಗ ನಮ್ಮ ಹಿಂದ ಕಡೆಯಿಂದ ಬಂದ KA01 MJ 7092 ಬೋರ್ವೆಲ್ ಲಾರಿಯ ಚಾಲಕ ಲಾರಿಯನ್ನು ಅತಿವೇಗ ಮತ್ತು ಅಜಾಗರೂಕತೆಯಿಂದ ಓಡಿಸಿಕೊಂಡು ಬಂದು ತಿರುವು ರಸ್ತೆಯಲ್ಲಿ ಬ್ರೇಕ್ ಹಾಕಿದಾಗ ತಕ್ಷಣ ಲಾರಿ ನಾವು ಹೋಗುತ್ತಿದ್ದು, ಅದರಲ್ಲಿ ನನ್ನ ತಮ್ಮ ನನ್ನ ಬಲಭಾಗದಲ್ಲಿ ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದು, ಮೋಹನನಿಗೆ ಬಲಭುಜದ ಕಡೆ ಲಾರಿ ಗುದ್ದಿದಾಗ ಬಲಭುಜ ತಲೆಗೆ ಪೆಟ್ಟು ಬಿದ್ದು ಲಾರಿಯ ಎಡಭಾಗದ ಡೋರ್ ಪಕ್ಕದಲ್ಲಿ ಕುಳಿತಿದ್ದ ಲಾರಿಯ ಕ್ಲೀನರ್ ಸಹ ಲಾರಿಯಿಂದ ಕೆಳಕ್ಕೆ ಡೋರ್ ಓಪನ್ ಆಗಿ ಕೆಳಗೆ ಬಿದ್ದನು. ತಕ್ಷಣ ನಾನು ಪೆಟ್ಟಾಗಿದ್ದವರನ್ನು ಆಂಬ್ಯುಲೆನ್ಸ್ಗೆ ಫೋನ್ ಮಾಡಿ ಆಂಬ್ಯುಲೆನ್ಸ್ ಬಂದ ನಂತರ ವಿಷಯ ತಿಳಿದು ಬಂದ ನಮ್ಮ ತಂದೆ ಲಿಂಗೇಗೌಡರು ಹಾಗೂ ನಾನು ಸೇರಿಕೊಂಡು ಹಾಸನಕ್ಕೆ ಆಂಬ್ಯುಲೆನ್ಸ್ನಲ್ಲಿ SSM ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆಗೆ ದಾಖಲು ಮಾಡಿದೆವು. ನಂತರ ಅಲ್ಲಿನ ವೈದ್ಯರು ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗೆ ನನ್ನ ತಮ್ಮ ಸ್ವಂತ. The manner of the accident explained is in the belated complaint lodged on 5th is that the rig lorry came, suddenly he applied brakes in the turning, front door cabin door opened, cleaner fell down from the lorry and the borewell rod hit against the claimant, resulting in injuries. This is the version introducing the vehicle with number. The very same persons who take him to BGS Global Hospital, Bangalore, have produced exhibit P3. Working at borewell. Borewell bere, rig number bere. Idu version of the accident, manner of the accident, involvement of the rig insured with me create lot of doubt that has not been explained. It is a misrepresented claim to create wrongful liability. ಇವ್ರು ಬೋರ್ವೆಲ್ ರಿಪೇರಿ ಮಾಡುವಾಗ ಏನೋ ಗಾಯ ಆಗಿದ್ರೆ ಯಾವುದೋ ಒಂದು ರಿಪೋರ್ಟ್ ಕೊಟ್ಟು ಮಾಡಿ ಪೊಲೀಸ್ನವರು ಒಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ.
What happened to the criminal case while with respect to the accident?
I have no information. I have no.
Yes. The next point.
ಅಷ್ಟೇ ಎಕ್ಸಿಬಿಟ್ P3 ಒಳಗಿರೋ ಕಂಟೆಂಟ್ಸ್ ಬಗ್ಗೆ PW1, PW2, PW3 ಹತ್ರ ಹೇಳಿಸಿದ್ವಿ. ಕ್ಲೈಮೆಂಟ್ಸ್ ಸದರಿ ಆಸ್ಪತ್ರೆಗೆ ಸೇರಿಸಿದಾಗ ಗಾಯ ಹೇಗಾಗಿದೆ ಎಂಬ ಬಗ್ಗೆ ಅವರೇ ಮಾಹಿತಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಂದ್ರೆ ಅಣ್ಣ ಮತ್ತು ತಂದೆ. ಅಣ್ಣ is examined as PW2.
What is PW2? PW2 is the complainant, right?
Yes.
The FIR.
Yes. My lords will kindly go to the cross-examination, last but one page, minute.
Yes.
ಅದರಲ್ಲಿ ಆಂಬ್ಯುಲೆನ್ಸ್ಗೆ ನಾನೇ ಫೋನ್ ಮಾಡಿದೆ. ನಮ್ಮ ತಂದೆ ಮತ್ತು ನಮ್ಮ ದೊಡ್ಡಪ್ಪನ ಮಗ ಚಂದ್ರ ಆ ಸಮಯದಲ್ಲಿದ್ದೆವು. ಬೆಳಗಿನ ಜಾವ 3 ಗಂಟೆವರೆಗೂ ಸಹ ನಾವು ಆಸ್ಪತ್ರೆಯಲ್ಲಿದ್ದೆವು. ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಯಾವ ರೀತಿ ಅಪಘಾತವಾಗಿದೆ ಎಂದು ನಾವು ಹೇಳಿದ್ದೇವೆ. So thus contents of exhibit P3 is proved with their own evidence. Involvement of any motor vehicle is not seen from exhibit P3. P3 comes into the police complaint comes into existence only after 3 days. Then kindly come to PW3 also, my lord.
One second. Where the medical records are produced, case sheet. No.
ಎಲ್ಲ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಬಗ್ಗೆ ಏನು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ.
Medical records does not mean bills. Exhibit 17 could read.
ಮೋಸ್ಟ್ಲಿ ಪೇಜ್ 135 ಒಂದ್ ಸರಿ ಏನ ತಮ್ಮಲ್ಲಿ ಇರೋದ್ರಲ್ಲಿ ನೋಡ್ಬೋದು.
ಒಂದು ನಿಮಿಷ. Page 137 in what, which document?
ತಾವು P17 ಅಂತ ತೆಗೆದ್ರಲ್ಲ MLC ಅಂತ ಇದೆ BGS ಗ್ಲೋಬಲ್ ಹಾಸ್ಪಿಟಲ್ ಅಂತ. ಅಲ್ಲಿ ಇಂಟರ್ನಲ್ ಪೇಜ್ 7 ಅಂತ ಕಾಣುತ್ತೆ.
ಎರಡಿದೆ, ಒಂದು ಬ್ಲೂ ಇಂಕ್ ಇದೆ, ಒಂದು ರೆಡ್ ಇಂಕ್ ಇದೆ. ಎರಡು ಬೇರೆ ಬೇರೆ ಇದೆ ಅದು. ಅದರಲ್ಲಿ ಎರಡನ್ನೂ ನೋಡ್ತಿದ್ದೇನೆ ನಾನು.
ಅಲ್ಲ, ಅದು ಪೇಜ್ 135 ಅಂತ ಏನೋ ಬರುತ್ತೆ ನೋಡಿ, ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಟಾಪ್ ಅಲ್ಲಿ 135 ಅಂತ ಇದೆ ನನ್ನ ಪೇಪರ್ ಅಲ್ಲಿ. ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡಿರೋದು.
Page 135 in red ink, which is page 51 in blue ink, is hematology investigation report. The another page 135 in blue ink,
yes,
which is page 208 in the red ink, is another report in the case sheet.
ಅಲ್ಲ, ಈ ಕೇಸ್ ಶೀಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಇದು. It is dated 3/4/2014. History given by Lingaya Gowda father ಅಂತ ಇದೆ. ಅದೇ ಅಷ್ಟೇ.
ಚಂದ್ರದು ಇದೆ, ಆದ್ರೆ ಪೇಜ್ ನಂಬರ್ ಅನೇಕ್ಷರ ಎಲ್ಲದು ಬೇರೆ.
ಹೌದು. ಅಲ್ಲ, ಇದನ್ನ ತಾವು ಓದ್ಬೇಕು. ಈಗ ಸಾರಿ, ಅಷ್ಟೇ. He was supervising a borewell installation. ಅಷ್ಟೇ. This is the basis on which I made a submission to my lord that there is, in all probabilities, the manner of the accident is that ಇವರು ಬೋರ್ವೆಲ್ ಇಳಿಸಕ್ ಹೋಗಿದ್ದಾರೆ, ಮೋಟ್ರು ಪೈಪು ಎಲ್ಲ ಇಳಿಸ್ತಾ ಬ್ಯಾಲೆನ್ಸ್ ತಪ್ಪಿ ಮೇಲೆ ಬಿದ್ದಿದೆ. 3 ದಿನ ಆದ್ಮೇಲೆ ಒಂದು ರಿಗ್ ಹುಡುಕ್ಬಿಟ್ಟು ಅದರ ನಂಬರ್ ಹಾಕಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನು ಈ ಅರ್ಲಿಯರ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಏನು ವ್ಯತ್ಯಾಸನೇ ಇಲ್ಲ. ವರ್ಕ್ ಪ್ಲೇಸ್ ಅಂತಿದೆ, ದಾರಿಲೆಲ್ಲೋ ರಿಗ್ ಹೊಡಿತು ಅಂತಿಲ್ಲ, ವರ್ಕ್ ಪ್ಲೇಸ್. ಇಲ್ಲಿ ಅವ್ರ ಅಪ್ಪ ಕೊಟ್ಟಿದ್ದಾರೆ ಇನ್ಫಾರ್ಮೇಶನ್. ದಟ್ಸ್ ವಾಟ್ ಐ ವಾಂಟೆಡ್ ಟು ಬ್ರಿಂಗ್ ಟು ಮೈ ಲಾರ್ಡ್ಸ್ ನೋಟಿಸ್. ಹಿಸ್ಟ್ರಿ ಗಿವನ್ ಬೈ ಲಿಂಗಯ್ಯ ಗೌಡ ಫಾದರ್. ಅಲ್ಲಿ ಬ್ರದರ್ ಕೊಟ್ಟಿದ್ದ ವರ್ಕ್ ಪ್ಲೇಸ್ ಇಂಜುರಿ ಅಂತ. ಇಲ್ಲಿ ಬೋರ್ವೆಲ್ ಇನ್ಸ್ಟಾಲೇಷನ್ ಆಗಿರೋದು ಅಂತ ಇದೆ. ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಬೋರ್ವೆಲ್ ನ ಇನ್ಸ್ಟಾಲ್ ಮಾಡುವಾಗ ಇದಾಗಿದೆ, ಅದಕ್ಕೆ ಒಂದು ಮೋಟರ್ ವೆಹಿಕಲ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಂತ ಸೃಷ್ಟಿ ಮಾಡಿದ್ದಾರೆ. ದಸ್ ರಾಂಗ್ಫುಲ್ ಲಯಬಿಲಿಟಿ ಇಸ್ ಕ್ರಿಯೇಟೆಡ್ ಅಂತ. ದಟ್ ಈಸ್ ಮೈ ಸಬ್ಮಿಷನ್. ಆಗಿದೆ.
Yes, please.
The only conclusion that could be drawn from these records and evidence of PW1 to PW4 is that this is a misrepresented claim, wherein an effort is made with the cooperation of the owner of the vehicle as well as the police to create wrongful liability on the insurance company to claim to receive compensation for an injury suffered elsewhere without involvement of the motor vehicle. Therefore, my appeal may kindly be allowed.
That is your argument in both the appeal.
ಇನ್ನೊಂದು ಅವರು probably they have sought for enhancement on the time. Firstly, there would not be any liability on me. If my appeal is allowed, then my lord, it is for them to decide what they would do with their appeal.
Yes, please.
Rising is that not in the course of not work overwhelm not this injury is sustained and they are relying on exhibit P3. Not, as per this exhibit P3, not the injured claimant not was accompanied, not his brother Sampath Kumar. Not this Chandru alias Chandrasekhar has been examined as PW3. Lord, he is the person, Lord, who give the information to the hospital authorities, Lord, regarding the accident. And this Chandru is not an eyewitness to the accident, my Lord. Lord, he has clarified, my Lord, he has given a evidence that Lord, he is not the eyewitness to the accident. Lord, he has given information, my Lord, which was not within his personal knowledge. ನಾನು ಅಪಘಾತವನ್ನು ಕಣ್ಣಾರೆ ನೋಡಿರುವುದಿಲ್ಲ, ನಾನು ತಪ್ಪಾಗಿ ಮಾಹಿತಿಯನ್ನು ತಿಳಿದ ಕಾರಣ ಸದರಿ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ವೈದ್ಯರ ಬಳಿ ತಪ್ಪಾಗಿ ಮಾಹಿತಿಯನ್ನು ನೀಡಿರುತ್ತೇನೆ. ನಂತರ ನನಗೆ ಅಪಘಾತದ ಬಗ್ಗೆ ಮಾಹಿತಿ ತಿಳಿದು ದಿನಾಂಕ 3/4/2014 ಬೆಳಗಿನ ಜಾವ 2:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಮತ್ತು ಅವರ ಅಣ್ಣ ಸಂಪತ್ ಇಬ್ಬರು ಕರಡೆವು ಗ್ರಾಮದ ಕಡೆ ನಡೆದುಕೊಂಡು ಬರುತ್ತಿರುವಾಗ ತಿರುವು ರಸ್ತೆಯಲ್ಲಿ ಹಿಂಬದಿಯಿಂದ ಬಂದ KA 01 MJ 7092 ಬೋರ್ವೆಲ್ ಲಾರಿ ಚಾಲಕ ತನ್ನ ಲಾರಿಯನ್ನು ಅತಿವೇಗ ಮತ್ತು ಅಜಾಗರೂಕತೆಯಲ್ಲಿ ಚಾಲನೆ ಮಾಡಿಕೊಂಡಿದ್ದರು. DL And the other ground, my lord, regarding the delay, my lord. But as per the records, my lord, the accident, after accident, my lord, initially, my lord, he took treatment at SSM hospital at Hassan. Thereafter, my lord, he went to Niman's hospital, my lord. And my lord, thereafter, he was shifted to Niman, BGS hospital, my lord, where he was undergone treatment, my lord. My lord, when he was very, my lord, sustained a previous injury to his head, my lord. The brother who is the complainant, my lord, was, my lord, concentrating on his, my lord, treatment, my lord, and my lord, even the police to record his statement, my lord, it took time, my lord. ಮೂರನೇ ತಾರೀಕು ಬೆಳಗ್ಗಿನ ಜಾವ 2:30 ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿದೆ.
First, the injured was taken to SSM hospital.
SSM hospital at Hassan.
Hassan. Are there any documents pertaining to the said hospital, SSM hospital?
It is not been.
Not been used.
Initially, my lord, was taken to Niman's hospital.
According to PW3, it was him who gave information to the hospital at VGS hospital, right? The medical records at VGS hospital shows that accident was due to fall of pipe in a workplace near borewell. So, according to BGS hospital records, the history of injury is at workplace near a borewell.
Because of the information given by PW3.
Information given by PW3.
Yes.
Fine. Take out the cross-examination of PW3. Cross-examination, first page, last two lines. One line behind that. Yes, BGS ಆಸ್ಪತ್ರೆಗೆ ಹೋದೆವು. Read it, please. Loudly.
ಆಸ್ಪತ್ರೆಗೆ ಹೋದೆವು. ಆಗ 9:30ರಿಂದ 10 ಗಂಟೆಯಾಗಿತ್ತು. BGS ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನಾನೇ ಗಾಯಾಳು ಜೊತೆ ಹೋದೆ. ಆ ಸಮಯದಲ್ಲಿ ಸಂಪತ್ ಕುಮಾರ್ ಔಷಧಿ ತರಲು ಹೋಗಿದ್ದರು. ನನ್ನ ಚಿಕ್ಕಪ್ಪ ಹೊರಗಡೆ ಇದ್ದರು. ಮನೆಯ ಬಳಿ ಇದ್ದಾಗಲೇ ಊರಿನ ಜನ ಸುತ್ತುಕೊಂಡಿದ್ದರು. ಅವರು ಬೋರ್ವೆಲ್ ಲಾರಿ ಬುದ್ಧಿ ಅಪಘಾತವಾಗಿದೆ ಎಂದು ಹೇಳಿದ್ದರು. ಆದ್ದರಿಂದ ನಾನು BGS ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಈ ವಿಷಯವನ್ನು ಹೇಳಿದ್ದೆ.
ಎಸ್,
ನಾನು BGS ಆಸ್ಪತ್ರೆಯಲ್ಲಿ
So, according to PW3 himself, about the history of the incident, he was aware and made known by the people near the house itself. And he was told by the people, according to him, that by the dashing of a borewell lorry, the incident has happened. According to him, he has stated very same thing before the doctors in BGS hospital. Then why should the BGS hospital doctors at several places in their records write that incident was near workplace while attending to a borewell, fall off a pipe, but not dash by a lorry? ಇವನ ಪ್ರಕಾರ BGS ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೋಗುವ ಮುಂಚೆಯೇ ಊರಿನ ಎಲ್ಲಾ ಜನರು ಹೇಳಿದ್ರ ಪ್ರಕಾರವು ಬೋರ್ವೆಲ್ ಲಾರಿ ಗುದ್ದಿ ಅಪಘಾತ ಆಗಿದೆ ಗೊತ್ತಿದೆ. ನಾನು ಅದನ್ನೇ BGS ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆದ್ರೆ ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರ್ತಕ್ಕಂತಹ ಹಾಸ್ಪಿಟಲ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಬೋರ್ವೆಲ್ ಲಾರಿ ಗುದ್ದಿ ಅಂತ ಇಲ್ಲ. ಬೋರ್ವೆಲ್ ಹತ್ತಿರ ಕೆಲಸ ಮಾಡ್ತಾ ಪೈಪ್ ಬಿದ್ದು very same witness.
In Chief Milord, he says that he is not the eyewitness.
He is not the eyewitness.
He is not the eyewitness.
But he says that I knew, I was told by several of the people that it was hit by a borewell lorry. Then why should he say that it was near workplace?
ತಪ್ಪಾಗಿ ಮಾಹಿತಿಯನ್ನು ತಿಳಿದ ಕಾರಣ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕೇಳಿದ್ರು ಅಂತ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿ.
ಏನು ವಕೀಲ್ರೆ?
ಹಿಸ್ಟ್ರಿ ಗಿವನ್ ಬೈ ಲಿಂಗಯ್ಯ ಗೌಡ ಫಾದರ್ ಅಂತ ಒಂದು ಎಂಟ್ರಿ ಇದೆ, ಅದರ ಬಗ್ಗೆ ಏನು ವಿವರಣೆ ಇಲ್ಲ. ತಾವು ನೋಡಿದ್ರಿ ಎಕ್ಸಿಬಿಟ್ P17 ನಲ್ಲಿ ಅವರ ಅಪ್ಪ ಈ ಇನ್ಫಾರ್ಮೇಶನ್.
ಈಗ ನೀವು ಇಬ್ಬರು ಏನ್ ನೋಡಿದ್ದೀರಿ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ನಾನ್ ನೋಡಿದ್ದೇನೆ.
ಹೌದು,
ಮುಂದಿನದನ್ನು ರಜತ ಪರದೆಯ ಮೇಲೆ ನೋಡಿ. ಮತ್ತೇನ್ರಿ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಓದ್ತಿದ್ರಿ?
Investigation is completed in the exhibit P7.
Yes, charge sheet.
And in my appeal, my lord,
What happened to that criminal case?
it's not on record, my lord, but it is told that my lord he has pleaded guilty.
ಅದನ್ನು ಸುಲಭವಾಗಿ ಮಾಡ್ತಾರೆ. ಇನ್ಮೇಲೆ ಗಿಲ್ಟಿ ಪ್ಲೀಡ್ ಮಾಡೋ ಸಂಖ್ಯೆ ಜಾಸ್ತಿ ಆಗ್ತಿದೆ. 50% ಡಿಸ್ಕೌಂಟ್ ಅಲ್ವೇ? Next.
And in my appeal, my lord, I have sought for enhancement of the income taken is 6,000. As per the chart, my lord, and the avocation of the injured, but it ought to have 8,500. And other two hits. That it's my lord, amenities is not awarded. And loss of income during laid up.
About the injury sustained by him.
Not yes, sustained, not biggest injury towards his traumatic brain injury.
What does it mean? How long he was inpatient? What is the laid up period?
It was discharged 17/4/2024 for 14 days. My lord, he was patient.
Time permits, the judgment to be dictated in the afternoon.
Number 52.
Your Lordship, in this case, I am appearing for a third respondent. On submission, Your Lordship, there is a double filing in this so far as this claim petition, this appeal is concerned. The same claimants had also filed one more appeal, that is MFA 294/2022, that came to be settled in the recent Lok Adalat, Your Lordship, held during the month of February.
Learned counsel for the appellant is physically present. Learned counsel for respondent number 2 appearing through video conference submits that the very same appellant has filed one more claim petition with respect to the very same accident.
Appeal, Your Lordship, for this honorable court.
One more appeal. One more
Appeal
appeal.
before this appeal court.
Appeal before this court with respect to the very same, as against the very same judgment and award.
Yes, yes, Your Lordship.
As against the same impugned judgment and award in MFA number so and so so and so.
294.
Yeah, what's the MFA number?
294/2022, which came to be settled for rupees 80,000 in the recent Lok Adalat held in the month of February, Your Lordship.
And the said MFA came to be settled. The said MFA already came to be settled in a Lok Adalat for a sum of rupees 80,000. With this, she submits that in view of already settlement of the matter in another MFA, the same cause of action, the present appeal deserves to be dismissed with exemplary cost. The learned counsel for the appellant submits that she is not aware of the alleged MFA 294 of 2022 and that she would ascertain the same and make her submission, for which she requires a week's accommodation. Time as prayed is granted.
Still number 53, B. Pramod.
Madam, last week matter was listed. My lords were pleased to direct me to file a typed copy of exhibit P6 and P10, my lords. I've done it, my lords. The whole certificate and discharge. Pardon me, lords. The memo I have typed copy. One submission, as far as possible, type copy ಹಾಕಿದೀನಿ. ಕೆಲವು ಕ್ಲಿಯರ್ ಇಲ್ದಿದ್ದು ಎಷ್ಟಾಗುತ್ತೋ ಅಷ್ಟು ಮಾಡಿಸಿ ಹಾಕಿ.
ಅದನ್ನೇ ನೀವು ಹಾಗೆ ಮಾಡ್ತೀರಿ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಡೈರೆಕ್ಷನ್ ಅಲ್ಲಿ
ಹೇಳಿದ್ರಿ.
ಮೆಡಿಕಲ್ ಅಂಡ್ ಇಂಜುರಿ ನೇಮ್ ಅಂತ ಬರೆದಿದ್ದೇನೆ.
ಅದು ಹಾಕಿದೀನಿ. ಅಲ್ಲಿ ಹೆಂಗೆ ಕಾಣಿಸಿದ್ಯೋ ಅದ್ರ ಪ್ರಕಾರನೇ
ಹೆಂಗೆ ಕಾಣಿಸಿದ್ಯೋ ಅದ್ರ ಪ್ರಕಾರ ಅಲ್ಲ ವಕೀಲ್ರೆ, ಅದ್ ಹೆಂಗೆ ಕಾಣಿಸಿದ್ಯೋ ನೀವು ಹಾಗೆ ಹಾಕಿದ್ರೆ ಅದ್ ಏನ್ ಬರೆದಿದ್ದಾರೆ ಅರ್ಥವಾಗುವುದಿಲ್ಲ ಅಂತ ಆ ಇಂಜುರಿ ಕನ್ಸಿಡರೇಷನ್ಗೆ ಬರಲ್ಲ. ದುಡ್ಡು ಬರ್ಬೇಕಾಗಿರೋದು ನಿಮಗೆ. ನೀವು ಅದ್ರದ್ದು ಏನ್ ಇಂಜುರಿ ಅಂತ ಹೇಳಿ ಒಬ್ಬ ಅದು ಡಾಕ್ಟರ್ನ ಕೇಳಿ ಅವನನ್ನ ಕೇಳಿ ಕರೆಕ್ಟ್ ಆಗಿ ತಿಳ್ಕೊಂಡು ಹಾಕ್ಬೇಕು. ಅಲ್ಲಿ ಏನ್ ಕಾಣಿಸುತ್ತೋ ಹಾಗೆ ಹಾಕಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮೆಡಿಕಲ್ ಟರ್ಮಿನಾಲಜಿಲಿ ಅದು ಗೊತ್ತಾಗದೆ ಹೋದ್ರೆ ಇಟ್ ಇಸ್ ಅನ್ ಅನ್ಕ್ಲಿಯರ್ ಇಂಜುರಿ. ಇಟ್ ಈಸ್ ಹಾರ್ಡ್ಲಿ ಡಿಫಿಕಲ್ಟ್ ಟು ಬಿಲೀವ್ ದಟ್ ಇಟ್ ಈಸ್ ಅನ್ ಇಂಜುರಿ ತಗೊಳ್ಬೇಕಾಗ್ತದೆ. ಅಥವಾ ಮ್ಯಾಕ್ಸಿಮಮ್ ಅದು ಸಿಂಪಲ್ ಇಂಜುರಿ ಆಗ್ತದೆ. ಎರಡು ತಗೊಂಡ್ರು ಲಾಸ್ ನಿಮಗೆ. ಕಸರತ್ತು ಮಾಡುವ ಜವಾಬ್ದಾರಿ ನಿಮ್ಮದೇ ಹೊರತು ನನ್ನದಲ್ಲ.
ಇರೋದು ಏನಿದೆ ನನಗೆ ಹೇಳಿದ್ದೀನಿ. ಯಾಕಂದ್ರೆ ಕೆಲವು ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಗೊತ್ತೇ ಆಗೋದಿಲ್ಲ. ಅದನ್ನು ಆದಷ್ಟು ಆ ಏನು ಟರ್ಮಿನಾಲಜಿ ಇದೆ ಅದು ಹಾಕಿದ್ದೀನಿ. ಐ ವಿಲ್ ಜಸ್ಟ್ ಪಾಯಿಂಟ್ ಔಟ್ ವಾಟ್ ಇಟ್ ಈಸ್ ಇಂಜುರಿ ಆಲ್ಸೋ.
ಯಾವ ಪ್ರಯತ್ನವನ್ನು ನೀವು ಏನದು ಇಂಜುರಿ ಅಂತ ಸರ್ಟೈನ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಮಾಡ್ಲಿ. ವೂಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಿ, ಅದನ್ನೇ 2, 3, 4 ಸರ್ತಿ ಓದಿದ್ದೀರಿ, ಅದನ್ನೇ ಟೈಪ್ ಮಾಡಿ ಹಾಕಿದ್ದೀರಿ.
More than whatever it is there in that document.
Consequently, ಏನಾಗ್ತದೆ? Probably the medical terminology might have shown a major injury. Being unable to read it and understand it perfectly, if you go by what we can get knowledge through this wound certificate by a cursory look and your alleged typed version. If you conclude to a lesser degree of injury, loss would be to the claimant.
2 minutes.
That's what I'm telling.
My difficulty, what was there, what was available, what I could understand, I got it. Now, exhibit P11 nodadrunu, it is a CT scan of this is also produced, wherein the injury part is mentioned clearly. Exhibit P11 so. Finding ಮತ್ತೆ impression ಅದೇ ಎರಡರಲ್ಲೂ details ಇದೆ regard these injuries, what he has sustained.
what the respondents say. Both of you were also given direction along with him with respect to the injuries. Have you completed the said direction? You have forgotten what direction was given.
Bills ಬಗ್ಗೆ ನೋಡಿ.
ಏನ್ ಡೈರೆಕ್ಷನ್ ಇತ್ತು ಅನ್ನೋದೇ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ. ವಕೀಲರು ಸಾಕ್ಷಿದಾರರುಗಳನ್ನ ವಿಟ್ನೆಸ್ಗಳನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದಕ್ಕಿಂತಲೂ ಕೋರ್ಟ್ ನಲ್ಲಿ ಜಡ್ಜ್ಗಳನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ತಾರೆ ಪ್ರತಿ ಸರ್ತಿ. ಅವ್ರಿಗೆ ಏನೋ ಕೇಸಲ್ಲಿ ಏನ್ ಮಾಡಬೇಕು ಗೊತ್ತಿಲ್ಲ. ಯಾರೋ ಒಬ್ರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಪಾರ್ಟಿ, ಆರ್ಡರ್ 1 ರೂಲ್ 10 ಹಾಕ್ಬೇಕು, ಆರ್ಡರ್ 22 ಹಾಕ್ಬೇಕು, ಅಥವಾ ಇನ್ನೊಂದೇನೋ, ಅಥವಾ ಬರೀ ಸೆಕ್ಷನ್ 151 ಏನು ಗೊತ್ತಿರಲ್ಲ. ಕೋರ್ಟ್ ನ 2-3 ಪ್ರಶ್ನೆ ಕೇಳ್ತಾರೆ. ಮಕ್ಕಳು ಬಾಯಿಂದ ಸತ್ಯ ಹೊರಡಿಸಿದಂಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಹೇಳ್ತದೆ ಇದನ್ನ ಮಾಡ್ರಿ, ಆಮೇಲೆ ಆಸ್ ಪರ್ ದ ಡೈರೆಕ್ಷನ್ ಆಫ್ ಯರ್ ಲಾಶಿಪ್ ಮಾಡ್ರಿ. ಏನೋ 2-3 ಬಹಳ ವೇಗ ಏನೋ ಹೇಳೋದು, ಕೋರ್ಟ್ ಅದ ಅಲ್ರಿ ಅದ ಹಂಗಲ್ಲ ಹಿಂಗೆ ಇರ್ತದೆ, ಗೊತ್ತಾಯ್ತಾ ಏನು ಅದನ್ನ ಮತ್ತೆ ವಾಪಸ್ ಹೇಳೋದು. ಏನ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ವಿ ಅನ್ನೋದೇ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಬಿಲ್ಸ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತೀರಿ ಒಂದು ಅಸ್ಯೂಮ್ ಮಾಡಿ.
ಬಿಲ್ಸ್ ಬಗ್ಗೆ ಹೇಳಿ.
The learned counsels for the respondents also to do the similar exercise or to ascertain the correctness of the typed version of those documents. Direction ಗೊತ್ತೇ ಇಲ್ಲ ನಿಮಗೆ ಇಬ್ಬರಿಗೂ ಏನು. ನಾನು ಕೂಡ ಡಿಕ್ಟೇಷನ್ ವಾಯ್ಸ್ ಪಕ್ಕದ ಕೋರ್ಟ್ಗಳಿಗೂ ಕೇಳಷ್ಟು ಗಟ್ಟಿ ಇರ್ತದೆ. ಈಗ ಅವರೇನು ಇಂಜುರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಅದು ತಪ್ಪಾಗಿ ಅರ್ಥೈಸಲ್ಪಟ್ರೆ ನಷ್ಟ ನಿಮಗಾಗ್ತದೆ. ಇರೋ ಇಂಜುರಿಗಿಂತ ಜಾಸ್ತಿ ಅಂತ ಹೇಳಿ ಏನಾದ್ರು ಇಂಟರ್ಪ್ರಿಟ್ ಆದ್ರೆ ಲಾಸ್ ಇರೋ ಇಂಜುರಿಗಿಂತ ಕಡಿಮೆ ಆದ್ರೆ ಲಾಸ್ ಟು ಹಿಮ್. At least he has made an effort to get a thing typed. You are also given the similar, directed to do similar exercise. Nothing. ಅವತ್ತಿನ ದಿವಸ ಡಾಕೆಟ್ ನಲ್ಲಿ ಜೂನಿಯರ್ ಕೈಯಲ್ಲಿ ಕೊಟ್ಟರೆ ಮತ್ತೆ ಅದು ವಾಪಸ್ ಬರೋದು ನಿನ್ನೆ ರಾತ್ರಿಯೂ ಅಲ್ಲ. MEC ಕೇಸ್ ರಾತ್ರಿ ಯಾರು ನೋಡ್ತಾರೆ, ಬೆಳಗ್ಗೆ ಕೋರ್ಟಿಗೆ ಬಂದಾಗಿದೆ. ಇಲ್ಲ ರೀ, MEC ಕೇಸಿನಲ್ಲಿ ದುಡ್ಡು ಜಾಸ್ತಿ ತಗೊಳ್ಳೋದು ಮಾತ್ರ ನಮ್ಮ ಜವಾಬ್ದಾರಿ ಅಂತ ಕ್ಲೈಮೆಂಟ್ ವಕೀಲರು ಇದ್ರೆ ಏನ್ ಮಾಡಿದ್ರೆ ಬಿಡು, ಕೋರ್ಟ್ ಕೊಡ್ತದಲ್ಲ, ಕೋರ್ಟ್ ಆರ್ಡರ್ ಅಂದ್ರೆ ಆಯ್ತು ಅನ್ನೋಷ್ಟು ಸರಳವಾಗಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ವಕೀಲರು ಇದ್ರೆ ಕಷ್ಟ ಸಾಧ್ಯ. ನ್ಯಾಯಾಧೀಶರಿಗೆ ಅದು ಹೊರೆ ಆಗ್ತದೆ. ಆ ಹೊರೆನ ನಿಜವಾದ ಅರ್ಥದಲ್ಲಿ ತಗೊಳ್ಳಂತ ನ್ಯಾಯಾಧೀಶನಿಗೆ ಕಷ್ಟ ಆಗ್ತದೆ. ಆ ನ್ಯಾಯಾಧೀಶನು ದುರದೃಷ್ಟವಶಾತ್ ನಮ್ಗೆ ಏನ್ಬಿಟ್ಟು ಸ್ವಲ್ಪ ಹೆಚ್ಚೋ ಕಡಿಮೆನೋ, ನಾನೇನ್ ಕೈಯಿಂದ ಕೊಡೋದಲ್ಲ, ಕೊಡೋರವ್ರು ಇಸ್ಕೊಳ್ಳೋರವ್ರು, ಕಡಿಮೆ ಬಿದ್ರೆ ಮೇಲ್ ಹೋಗ್ತಾರೆ, ಒಪ್ಪಿಗೆ ಇವ್ರು ಕೊಡ್ತಾರೆ. ನಾನೇ ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳಿ. ಐ ವಿಲ್ ಬಿ ದಿ ಗುಡ್ ಬೈ ಅವಾರ್ಡಿಂಗ್ ಲಿಬರಲ್ ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ಹ್ಯುಮ್ಯಾನಿಟಿ, ಸೋಷಿಯಲ್ ವೆಲ್ಫೇರ್ ಲೆಜಿಸ್ಲೇಷನ್, ಎ ಬೆನಿಫಿಷಿಯಲ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಅಂತ ಒಂದು ಶೀಲ್ಡ್ ಹಿಡ್ಕೊಂಡು ಅವರು ಸುಲಭದಲ್ಲಿಯೇ ಬ್ಯಾಟಿಂಗ್ ಮಾಡಿಬಿಟ್ರೆ ವೇರ್ ಡೂ ದ ಜಸ್ಟಿಸ್ ಶುಡ್ ಗೋ. ದುರಂತ. We will continue in the afternoon. ಈಗಿನ
ಅಲ್ಲ ಇದು ಸ್ಕೂಟಿ ಇರ್ಬೇಕು, 2 ಸ್ಕೂಟಿನೇ. ಎರಡರಲ್ಲೂ ಹೇಳಿದಾರೆ, ಏನ್ ಮಾಡ್ತೀರಾ? ವಿಲ್ ಕಂಟಿನ್ಯೂ ಇನ್ ಆಫ್ಟರ್ನೂನ್ ಅಂತ ಹೊಸವ್ರು ಹೇಳಿದ. ನೀವು ಬರಲ್ವಾ? ನೀವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕಿಲ್ಲ.
Pronouncement of judgment. Number 58.
I represent case that is appellant.
It is allowed in part. Compensation is fixed at rupees 14,77,008.
Please.
It is on R2.
But again, the registry has put up the memo. By the appellant seeking dispensation of notice to respondent number 2, respondent number 1. In the left, R1 dispensation. This all can be.
Yeah, sure.
To notice now. So notice to respond. Or submission. Put up the memo seeking dispensation. Need assurance. Appellant to pay the process and furnish copies in the registry to issue notice to the respondent number 2 in a week from today. Then call for a
See number 32. Pramodar Gowda TP. Declare question out of this.
Request of the learned tax counsel for the appellant, list the matter on move. Move.
Yes. See number 33. Raghunath Prasad, BS.
Okay, none appear. 31.
Number 47. Ashokian Patel. 5 minutes.
Shankar S. Samprati. FA number is 1246 of 2023.
Counsel for the appellant. Submits that as against the very same judgment and award one more MFA being connected matter one ಹೇಳ್ತಾರೆ.
How arising out of the same
MFA number
1246 of 2023.
also is pending. Wish to connect for the other ಹಾಕಿ next week. Correct.
Number 53. P. Pramod, R.S. Maralaya for R2, Ravish Benny for R4.
What are all the heads of compensation you expect compensation in the matter?
He was hospitalized, and he was inpatient for one.
Heads of the
Please no. Later period, minutes.
pain and suffering.
Please no. Later period.
Later period what? Income or loss or
Loss of income during the later period.
ದುಡ್ಡು ಪೂರ್ತಿ ಬೇಕು ಮಾತಾಡೋದು ಯಾಕೆ ಇಷ್ಟ ಮಾತಾಡ್ತೀರಿ?
Sorry. And the High Court has granted minutes that amount 6,658 is granted. It is available at page number 17 minutes. Amount was to be retained.
One bill was double, right?
The bill was
One bill was in duplicate.
they were produced
Twice a bill.
3,000 ಅಂತ ಎರಡು.
3,000
ಹೌದು. ಅದೆಲ್ಲ ಡಿಡಕ್ಟ್ ಆಗಿದೆ.
ಆಗಿದೆಯಾ ಅದು?
ಅದಾಗಿದೆ. ಎರಡರಲ್ಲಿ ಒಂದು ಡಿಡಕ್ಟ್ ಆಗಿದೆ. ಎರಡು ಗೊತ್ತಿಲ್ಲ.
To say 8,213.
ಏನು ಅದೊಂದು ಸ್ಲಿಪ್ ನಲ್ಲಿ ಬರೋದು ಇರಬೇಕಲ್ವೇ? ಕೋರ್ಟ್ ಹೇಳಿಗೆ ಕೋರ್ಟ್ ಮಾಡ್ತಿದ್ದೀರಿ. Vehicle bill 6,658.
Okay. Generation, convenience charges, my lords, and loss of amenities.
Then
But the trial court minutes has not considered about the disability after whatever it is stated minutes.
what a disability is there?
He has stated it is about 32% to the right lower.
On what basis? No basis at all. He has not even seen the X-ray film. He has not even seen the medical sheet. Based upon the discharge summary and the request of the party, he has given disability. ಇದೆಲ್ಲ ನೋಡಿನೇ ಗ್ಲೋಬಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ನೀವೇ ಹೇಳಿರೋ ಪ್ರಕಾರ ನಿಮ್ಮದೇ ಸ್ಪ್ಲಿಟ್ ಆಫ್ ಫಿಗರ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಅವ್ರು ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು ಅರ್ಧನೂ ಬರಲ್ಲ. ಟೇಕ್ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ವಿಲ್ ಟೇಕ್ 20,000 rupees. Loss during laid up period. ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿಯಲ್ಲಿ ಇರೋದು 1 ವಾರ. ನೀವು 1 ತಿಂಗಳು ಎಲ್ಲಿದ್ದಾರೆ ಕೊಡ್ರಿ ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿ ಕೊಡಿ. ಅಸೆಟಬಲಮ್ ಆಪರೇಷನ್ಗೆ 1 ತಿಂಗಳು ಇಟ್ಕೊಡಲ್ಲ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ. 1 ವಾರ 9 ದಿವಸ ಮ್ಯಾಕ್ಸಿಮಮ್.
Date of admission is 17/5/2018. 18/6/2018 is the date of discharge, my lords.
ಫ್ರೀ ಊಟ ಕೊಡ್ತಾರೆ, ಬೆಡ್ ಖಾಲಿ ಇದೆ, ಮಲ್ಕೊಳಪ್ಪ ಅಂದಿದ್ದಾರೆ.
Yes.
ಈ ಪೇಷಂಟ್ ಆಗಿ 1 ತಿಂಗಳಿತ್ತು as a the another 2 months it can be added for loss of percentage of the year 2018. ಅವಾಗ ಲೋಕಲ್ ಚಾರ್ಟ್ ಇದ್ರ ಪ್ರಕಾರ 12,500 ತಗೊಂಡ್ರೆ ಅದರಲ್ಲಿ ಆಡ್ ನಲ್ಲಿ 37,500 attendance charges for a month for the hospital. That means and pain and suffering minutes. These are the heads.
There was no surgery and only conservative treatment. Para number 19 of the 11th page, it is very clearly exhibit report in X-rays. Signs of fracture is not appearing for the eyes, bare eyes. The petitioner has not produced X-rays taken in the district hospital.
What you are reading?
Judgment.
Judgment ಓದ್ಬೇಡಿ ನೀವು. ಜಜ್ಮೆಂಟ್ ಓದೋದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಲ್ಲ.
PW2 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲೂ ಅವರು ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ. ನಾನು ಅರ್ಜಿದಾರರಿಗೆ ಚಿಕಿತ್ಸೆ ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತು ಶಸ್ತ್ರಚಿಕಿತ್ಸೆ ಮಾಡಿಲ್ಲ.
ಮಾಡ್ಲೇಬೇಕಂತಿಲ್ವೇ? ಮಾಡಿರೋ ಡಾಕ್ಟ್ರೇ ಹೇಳ್ಬೇಕಂತಿಲ್ಲ. ಇದನ್ನ ಆರ್ಥೋಪೆಡಿಕ್ ಸರ್ಜನ್ ಅಂತವ್ರನ್ನೆಲ್ಲ ನೀವೇ ಸಾಕಿದ್ದೀರಿ. ಹೆಚ್ಚಿನ ವಕೀಲರುಗಳು MEC ಮಾಡೋರು. ನನಗೆ ಯಾಕೆ ಹೇಳಲಿಕ್ಕೆ ಹೆದರಿಕೆ ಸಂಕೋಚ ಅಲ್ವೇ? ನೆಟ್ಟಿಗೆ ನಿಯತಿಲ್ ದುಡಿದ ಡಾಕ್ಟರ್ ಹತ್ರ ಹೋಗ್ತೀರಿ, ಸ್ವಾಮಿ ಒಂದು ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇಕು ಕೊಡ್ರಿ. ಅವ್ರು ಏನಪ್ಪ ಕೊಡೋದು, ಏನಿಲ್ಲ, ಏನ್ ಗೊತ್ತಾಗಲ್ಲ, ಎಲ್ಲ ಡಾಕ್ಟ್ರೇ ನಿಮ್ಗೆ ಗೊತ್ತಲ್ಲ, ಕೊಡ್ರಿ. ಅವ್ರೇನೋ ಇಲ್ಲಪ್ಪ ಹಂಗೆಲ್ಲ ನಾವು ಸುಳ್ಳೆ ಬರ್ದ್ರ ಆಮೇಲೆ ನಮ್ಮ ಮೇಲೆ ಏನಾದ್ರು ಆಕ್ಷನ್ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ, ಏನ್ ಪರವಾಗಿಲ್ಲ ಡಾಕ್ಟ್ರೇ ಕೊಡ್ರಿ. ಅಪ್ಪ 4% ಕೊಡೋದು ನೋಡು ಡಾಕ್ಟ್ರೇ, ನೀವೇನ್ ಕೊಡ್ತೀರಿ ಅದ್ರಲ್ಲಿ 25% ಕೋರ್ಟ್ ಒಪ್ಪಲ್ಲ, ಹಂಗಾಗಿ ನೀವು ಸ್ವಲ್ಪ ಜಾಸ್ತಿನೇ ಕೊಡ್ಬೇಕು. ನನ್ನ ಮಗಳು ಡಾಕ್ಟರ್, 5 ಜನ ಡಾಕ್ಟರ್ಗಳು ಸನದ್ನ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಸಿದ್ರು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಇದ್ದಾಗ. ಆಮೇಲೆ ನಾನು ಆ ಪ್ಲೇಸ್ ನಲ್ಲಿ ಇದ್ದಾಗ ಅವ್ರು ಒಬ್ರಿಗೂ ಡಿಸ್ಚಾರ್ಜ್ ಸರ್ಟಿಫಿಕೇಟ್, ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲಿಲ್ಲ ಆರ್ಥೋಪೆಡಿಷಿಯನ್ಸ್. ಆಮೇಲೆ ಅವ್ರು ಸನದ್ ರಿಸ್ಟೋರ್ ಆಯ್ತು ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ಇಂಡಿಯಾದಿಂದ, ಮತ್ತೆಲ್ಲ ಮಾಡ್ತಿದ್ದಾರೆ. ನಾವು ಎಲ್ಲಿಗೆ ಹೇಳ್ಕೊಂಡು ಹೋಗ್ತೇವೆ ಸೊಸೈಟಿ? We ourselves do that only because of money. ನಮಗೆ ಯಾರಿಗೂ ಹೆಚ್ಚಿನ ಜನಗಳಿಗೆ ನಾವು ಬಡವರು, ನಾವು ರೋಗಿಷ್ಠರು, ನಾವು ಅಸಹಾಯಕರು, ನಾವು ಅಸಮರ್ಥರು ಅಂತ ಹೇಳ್ಕೊಳ್ಳಿಕ್ಕೆ ಸಂಕೋಚವೇ ಇಲ್ಲ. ಏನಾದ್ರೂ ನಮಗೆ ಹಾಗೆ ಸಿಗ್ತದೆ, ಪುಕ್ಕಟೆ ಸಿಗುತ್ತೆ ಅಂದ್ರೆ ಯಾವ ಮಟ್ಟದ ದುರ್ಗುಣಗಳು ಅಥವಾ ವೀಕ್ನೆಸ್ಗಳು, ಅಶಕ್ತತೆಗಳು ಅವೆಲ್ಲವನ್ನೂ ನಾವು ಸ್ವೀಕರಿಸ್ತೇವೆ. ಗ್ಯಾಸ್ ಸಿಲಿಂಡರ್ ಸಬ್ಸಿಡಿ ಬರ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರಿಟರ್ನ್ ಬೇಕಾದ್ರೆ ನಾನು 6 ಲಕ್ಷ ರೂಪಾಯಿ ತೋರಿಸ್ತೇನೆ, 16 ಲಕ್ಷ ರೂಪಾಯಿ ತೋರಿಸ್ತೇನೆ, ಅಲ್ಲಿ ನಾನು ಸಬ್ಸಿಡಿದು ಬೇಕು, ಸಬ್ಸಿಡಿ ತಗೊಳ್ತೇನೆ. ಏನೇನೋ ಫ್ರೀ ಇದೆ ಅದನ್ನ ತಗೊಳ್ತೇನೆ. ದಿಸ್ ಈಸ್ ಅವರ್ ವೇ ಆಫ್ ಲೈಫ್. ಮಾಡ್ಲಿ, ಸಾಮಾನ್ಯ ಜನಗಳು ಮಾಡ್ಲಿ. ವಕೀಲರುಗಳು ನಾವು ನಮ್ಮ ಹತ್ರ ಬರೋ ಕಕ್ಷಿದಾರರಿಗೆ ಅಯ್ಯ ವಕೀಲ್ಗಿರಿ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ಬರೀ ಏನೋ ಸುಳ್ಳಳಿ ಏನೋ ಕೊಡ್ಸೋದಲ್ಲ, ಅದು ವಕಾಲತ್ತಲ್ಲ, ವಕೀಲ್ಗಿರಿ ಅಲ್ಲ. ನಿನಗೆ ಅರ್ಹತೆ ಎಷ್ಟಿದೆ ಅದನ್ನ ಕೊಡಿಸ್ಲಿಕ್ಕೆ ನಾನು ಹೋರಾಡ್ತೇನೆ, ದಟ್ ಈಸ್ ವಕೀಲ್ಗಿರಿ. ಇಲ್ಲವೇ ಇಲ್ಲ, ಈಗ ಅಂತ ಕಾನ್ಸೆಪ್ಟೇ ಇಲ್ಲ. ಅಂಥದನ್ನೇನಾದ್ರು ನಾವು ಹೇಳಲಿಕ್ಕೆ ಹೊರಟ್ವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಕೇಳಲಿಕ್ಕೂ ಪತ್ತೆ ಆಗಲ್ಲ. ಎದೋಗ್ತಾರೆ, ಅಯ್ಯೋ ಏನೋ ಮಾತಾಡ್ತಾರೆ. ದುರಂತ. ಅಷ್ಟೆಲ್ಲ ಮಾಡಿದವ್ರು ನಾವು ನಮ್ಮ ಮಕ್ಕಳನ್ನ ಫಾರಿನ್ಗೆ ಕಳಿಸ್ಬೇಕು. ನಮ್ಮ ಮಕ್ಕಳು ಲಾ ಇಲ್ಲಿ ಮಾಡಬಾರ್ದು, PG ಅವ್ರು ಇನ್ನೊಂದ್ ಕಡೆನೇ ಮಾಡ್ಬೇಕು, ಬೇರೆ ಕಡೆನೇ ಮಾಡ್ಬೇಕು. ನಮ್ಮ ಲೀಗಲ್ ಸಿಸ್ಟಮ್ನ ನಾವು ವೀಕ್ ಮಾಡಿ ನಮ್ಮ ಮಕ್ಕಳನ್ನ ನಾವು ಬೇರೆ ಕಡೆ ಕಳಿಸಿ ಅದನ್ನ ದೊಡ್ಡದಾಗಿ ನಾವು ಸ್ನೇಹಿತರ ಜೊತೆಗೆ ರಿಲೇಷನ್ ಅಲ್ಲಿ ಹೇಳ್ಕೊಳ್ತೀವಿ. ನನ್ನ ದೇಶನ ದುರ್ಬಲಗೊಳಿಸುವ ದಿಕ್ಕಿನಲ್ಲಿ ಮತ್ತಷ್ಟು ಕೊಡುಗೆಯನ್ನ ನೀಡಿ ನಾನು ನನ್ನ ಮಕ್ಕಳನ್ನ ಬೇರೆ ಕಡೆಗೆ ಕಳಿಸಿದೆ. ಆ ಮಕ್ಕಳ ಹೆಸರಲ್ಲಿ ಆಸ್ತಿ ಇಲ್ಲಿ ಮಾಡಿರ್ತೇನೆ. ನೋಡಿ, ನಿಮ್ ರಿಲೇಷನ್ ಅಲ್ಲಿ ನೋಡಿ, ಅವ್ರ ರಿಲೇಷನ್ ನೋಡಿ, ನನ್ನ ರಿಲೇಷನ್ ನೋಡಿ, ಎಲ್ಲ ಫಾರಿನ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. ಆಸ್ತಿ ಪಾಸ್ತಿಗಳು ಇಂಡಿಯಾದಲ್ಲಿ ಇರ್ತಾರೆ. ಅವ್ರಿಗೆ ಇಂಡಿಯನ್ ಸಿಟಿಜನ್ಶಿಪ್ ಬೇಡ, ಇಂಡಿಯನ್ ಬೆನಿಫಿಟ್ಸ್ ಬೇಕು.
ಅವ್ರಿಗೆ ಸಿಟಿಸನ್ಶಿಪ್ ಫಾರಿನ್ ಬೇಕು, ಮೆಡಿಕಲ್ ಎಜುಕೇಶನ್ ಇಲ್ಲಿದು ಬೇಕು. ಇಲ್ಲಿ ಎಜುಕೇಶನ್ ಆದ್ರ ಮೇಲೆ ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅವ್ರಿಗೆ. ಯಾಕೆ? ಬೈ ಬರ್ತ್ ಈಸ್ ಅ ಫಾರಿನ್ ನ್ಯಾಷನ್. ಬೈ ಬರ್ತ್ ಈಸ್ ಅ ಫಾರಿನ್ ನ್ಯಾಷನ್. ಆದ್ರೆ ಅವ್ರ ಅಪ್ಪ ಅಮ್ಮ ಇಲ್ಲಿ, ಅವರಿಗೆ ಆ ಸೈಟು ಈ ಸೈಟು, ಡಾಲರ್ ಕಾಲೋನಿಯಲ್ಲಿ, ರಾಜಮಹಲ್ ವಿಲಾಸಲ್ಲಿ, ಜಯನಗರದಲ್ಲಿ, ಸದಾಶಿವ ನಗರದಲ್ಲಿ ಎಲ್ಲ ಆಸ್ತಿಗಳನ್ನೆಲ್ಲ ಮಾಡಿ ಇಟ್ಕೊಳ್ಬೇಕು. ಅದನ್ನೆಲ್ಲ ಬ್ರೋಕರ್ಗೆ ಹೇಳಿ ಎಲ್ಲ ಮಾಡಿ ಬಾಡಿಗೆ ಕೊಟ್ಟು ಅದನ್ನೆಲ್ಲ ಪ್ರತಿ ತಿಂಗಳು ವಸೂಲು ಮಾಡಿ ಲೆಕ್ಕ ಇಟ್ಟು ಮಗನಿಗೋ ಮಗಳಿಗೋ ಈ ತಿಂಗಳು 13 ಲಕ್ಷ ರೂಪಾಯಿ ಬಾಡಿಗೆಗಳು ಬಂದಿದೆ, ಇಷ್ಟು ರಿಪೇರಿಗೆ ಹೋಗಿದೆ, ಇಷ್ಟು ಇದಕ್ಕೆ ಹೋಗಿದೆ. ಅಪ್ಪ ಅಮ್ಮನ ರಿಟೈರ್ ಆದ್ರ ಮೇಲೆ ಇನ್ನೇನು ಕೆಲಸ? ಫಸ್ಟ್ 3 ವರ್ಷ 4 ವರ್ಷ ಅಮೆರಿಕದಲ್ಲಿ ಹೋಗಿ ಅಥವಾ ಜರ್ಮನಿಗೋ ಕೆನಡಾಕ್ಕೆ ಹೋಗಿ ಮೊಮ್ಮಕ್ಕಳು ಡೈಪರ್ ಬದಲಾಯಿಸಿ, ಆಮೇಲೆ ಬೇಬಿ ಸಿಟ್ಟಿಂಗ್ ಮಾಡೋದು, ಆಮೇಲೆ ಈ ಅಕೌಂಟ್ಗಳನ್ನೆಲ್ಲ ಇಡೋದು, ಆಮೇಲೆ ಮಕ್ಕಳನ್ನ ಬಂದಾಗ ಅವ್ರ ಜೊತೆ ಒಂದು ಕಾರಲ್ಲೋ ಟೆಂಪೋ ಟ್ರಾವೆಲರ್ನಲ್ಲೋ ಅವರು ಆ ನೆಂಟ್ರ ಮನೆ ಈ ನೆಂಟ್ರ ಮನೆ 15 ದಿವಸದೊಳಗೆ ಆಗ್ಬೇಕು ಎಲ್ಲದೂ ಅವರಿಗೆ. ಯಾವ್ದೋ ಒಂದು ದೇವ್ರ ಸ್ಥಳನೋ ಅಂತ ಹೋದ್ರೆ ಅಲ್ಲಿಗೆಲ್ಲ ಹೋಗಿ ಬಂದು ಮತ್ತೆ ಕೆಂಪೇಗೌಡ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಏರ್ಪೋರ್ಟ್ ಅಲ್ಲಿ ಮಕ್ಕಳು ನಿಲ್ಸಿ ಟಾಟಾ ಮಾಡಿ ಕಳಿಸಿದ್ರೆ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಅಲ್ಲಿವರೆಗೆ ಇದೇ ರೊಟೀನ್. ಇಷ್ಟೆಲ್ಲ ಮಾಡಿದವರು ಬೆಳಗ್ಗೆ ವಾಕಿಂಗ್ ಹೋದಾಗ ಫ್ರೆಂಡ್ಸ್ಗಳಿದ್ರು, ನೋ ಮೈ ಸನ್ ಇನ್ ಅಮೆರಿಕಾ ಸೇಫ್, ಅಷ್ಟೇ ಅವ್ರ ಖುಷಿ ಜೀವನದಲ್ಲಿ. ಅಷ್ಟೇ ಕೆಲವೊಂದು ಕಾಲ್ಪನಿಕ ಸಂತೋಷನ ಅವ್ರಿಗೆ ಅವರೇ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಕೊಂಡು ಅದನ್ನೇ ಪುನರಾವರ್ತಿಸಿ ಅದರಲ್ಲೇ ಸಂತೋಷ ಪಟ್ಟು ಜೀವನ ಅದರಲ್ಲೇ ಕಳೆದು ಒಂದು ದಿವಸ ಗೊತ್ತಾಗ್ತಾನೆ. ಜೀವನ ಏನ್ರಿ? ಜೀವನ ಏನ್ರಿ? ಅವೆಲ್ಲ ಯಾಕಾಗ್ತವೆ? ಇಂಥದ್ರಲ್ಲೆಲ್ಲ ದುರಾಸೆಗಳು ಬಂದು ತಗೊಳ್ರಿ. Claimants appeal for enhancement of compensation injury case. Summary of the case of the claimant before the tribunal was that on the date 17/5/2018, he along with others were traveling in a tempo track Tufan motor vehicle bearing registration number KA34 A7102 from Hiriyuru towards Rudramanahali village. When the said vehicle came near Garani Cross on National Highway 150 bracket A, Challakere Taluk, at about 2 p.m., the driver of the said tempo tracks vehicle drove the same in a rash and negligent manner and dashed to the hind portion of a parked lorry bearing registration number RJ01GB8625. Full stop. Due to the said road traffic accident, claimant sustained previous injuries to both his legs, thighs, lower back, hip joint, and skull. Immediately, he was shifted to Government Hospital, Talak, and after first aid treatment, he was shifted to District Hospital, Chitradurga, where he underwent CT scan and diagnosed for fracture of posterior dislocation of femur head on right side, rim fracture of acetabulum. The claimant has stated that he has undergone surgical operation where the implants were inserted and had spent a sum of ₹1 lakh towards his treatment.
stating that prior to the accident, he was doing agricultural and milk vending business and was earning a sum of ₹20,000 per month. However, due to the injuries sustained by him in the accident, he could not continue with his avocation as claimed in total compensation of a sum of rupees. ಎಷ್ಟು ಹೇಳಿದಿರಿ ನಿಮ್ಮದು 20 lakhs rupees from the respondent number. 154 remaining. The owner of the offending vehicles as the respondent number 1 and 3 and the insurer of the alleged offending vehicles at respondent number 2 and 4 respectively. In response to the notice served upon them, the response number 2 and 4 have filed their separate statement of objection denying the manner of occurrence of accident and the age, income, and occupation of the claimant. Respondent number 2 further stated that the liability is subject to the terms and conditions of the policy and the validity of the documents of the insured vehicle. However, it contended that the accident was solely due to the rash and negligent driving of the tempo proof on tracks vehicle. The respondent number 4 contended. The respondent number 4, though stated that the policy of insurance with respect to the tempo proof on tracks vehicle was enforced, however, he contended that the alleged road traffic accident has occurred due to rash and negligent act on the part of the driver of the lorry bearing registration number RJ01GB8625, parking the said lorry in the middle of the road without following the traffic regulations. And so on to examine the relevant offense. The tribunal awarded a global compensation of a sum of ₹1 lakh. The tribunal 1 lakh. However, it held that however, it apportioned the liability to pay compensation at 75% to the owner and insurer of the tempo tracks proof on vehicle bearing registration number KA34A7102 and remaining 25% to the on the part of owner and insurer of the lorry bearing registration number RJ01GB8625. %, to the respondent number 3 and 4, who are the owner and insurer. Correct. Remaining 25% to the respondents number 1 and 2, who are the owner and insurer of lorry RJ01. Agreed by the same claimant has filed. Accident in question is not in dispute. Claimant got himself examined as PW1, who in his examination chief has reiterated the contention taken up by him in his claim petition. In support of his contention, he has got produced documents from exhibits P1 to P5, which inter alia includes copies of complaint, FIR, scene of offense Panchanama, 2 motor vehicle inspection reports, wound certificate, charge sheet, discharge card, and a disability certificate. Rash negligent driving is properly. Apportionment of liability among the respondents before the tribunal has not been disputed or objected to by either the appellant in this appeal or by the respondents. As such, the apportionment of liability at 25% to the owner and insurer of the lorry bearing registration number RJ01GB 8625 and remaining 75% on the part of the respondent number 3 and 4, that is the owner and insurer of the Tempo Trax Tufan motor vehicle bearing registration number KA34A7102. It will be accepted and proceeded accordingly. As such, the only question that remains for consideration is regarding the quantum of the compensation awarded by the tribunal. Admittedly, the tribunal, even though made an attempt to discuss the entitlement of the compensation at different head to the claimant, however, it ended up in ascertaining the compensation under the head of medical expenses only, which is also at rupees 6,658 rupees. However, with respect to compensation under other heads, instead of ascertaining the entitlement of the claimant, the tribunal opining that global compensation can be ordered, proceeded to award in total a sum of rupees 1 lakh at the global compensation. Learned counsel for the appellant says that the tribunal, in his argument, submitted that the tribunal ought to have calculated the compensation under different heads under entitlement for the claimant and should have arrived at a scientific quantum of compensation. Learned counsel for which respondent you are? Respondent number 2. Learned counsel for respondent number 2. ಬೆಳಗ್ಗೆ ಯಾರಿದ್ರು ಇನ್ನೊಬ್ಬರು ನಿಮ್ಮ ಜೊತೆಗೆ and learned counsel for respondent number 4. In their argument, submit that in the absence of necessary materials before it, the tribunal had rightly assessed the global compensation and fixed it at a reasonable amount of rupees 1 lakh. As such, the same does not warrant any interference at the hands of this court. From a perusal of the record and the evidence led by the parties, both oral and documentary, can be noticed that there are sufficient material to ascertain the quantum of compensation under different heads. The wound certificate at Exhibit P6 and the discharge card at Exhibit P10, coupled with the disability certificate at Exhibit P8, speaks about the nature of the injury suffered by the claimant in the road traffic accident. Those documents would so to show that in the road traffic accident, the claimant sustained injuries to his right hip, causing fracture of posterior superior lip of acetabulum on the right side. The X-ray report, which is also referred to both in the discharge summary as well in the wound certificate, confirms the same. The opinion of the doctor who was Dr. N. Venkateswara Reddy, an orthopedic surgeon who was examined as PW2, also on the similar line. According to the discharge card at exhibit P10, the claimant was treated as inpatient in the district hospital Chitradurga for a month from 17/5/2018 to 18/6/2018. As such, he should have necessarily suffered a considerable pain. Thus, he is entitled for a compensation of a sum of rupees 30,000. For pain and suffering suffered by him. Next. Though the claimant as PW1 has stated that at the time of accident he was doing agriculture and milk vending business and was earning a sum of rupees 20,000 per month. But admittedly, there are no documents to support his contention. As such, a notional income is required to be taken in the instant case. The road traffic accident in the instant case has occurred on 17/5/2018. A large number of the motor vehicle accident claim tribunals in the state are taking the notional income for the said year 2018 at rupees 12,500 per month. As such, in the instant case also, the notional income of the claimant is to be taken at rupees 12,500. The discharge summary go to show that he was inpatient in the hospital for a month. As such, it has to be taken at the lowest end that he was laid up for a period of 1 month. As such, towards loss of income during laid up period, he is entitled for a compensation of a sum of rupees 4,500. Though the claimant has contended that towards the medical expenses he has spent a sum of rupees 1 lakh. However, admittedly, there are no medical bills to support his contention. On the other hand, the discharge summary at exhibit P10 shows that he was treated as inpatient in a district government hospital in Chitradurga. As such, it is unbelievable that he has incurred such an expense towards medical expenditure. On the other hand, the medical bills produced by him at exhibit P13 with prescriptions at exhibit P12 though arrives at a sum of rupees 10,933 in total. However, after deducting the repetitive bills, including the one for CT scan, the total eligible amount for reimbursement is 6,658. The same is the assessment made by the tribunal also. As such, towards medical expenses, the claimant is entitled for a compensation of the sum of 6,658. Towards the nutritious food diet, attendant charges, conveyance and incidental expenses for the said laid up period in the hospital for 1 month. I am of the view that reasonable compensation would be a sum of rupees 15,000 rupees. As such, the claimant is entitled for the sum of rupees 15,000 under this said head. Due to the fractured injury suffered by him near the hip joint, and by virtue of the dislocation of femoral head on the right side, the claimant should have suffered loss of community. As such, towards loss of communities, he is entitled for the compensation of the sum of rupees 10,000. The claimant has also contended that the injuries suffered by him, he is suffering with permanent partial disability and has suffered loss of income as he could not continue his avocation as an agriculturist and milk vendor. In that regard, he got examined an orthopedic surgeon as PW2, who has stated that he has examined the claimant and studied the discharge summary and other details and has assessed the disability. The said witness, apart from identifying the disability certificate at exhibit P8 as issued by him, has stated that has noticed the presence of disability with the claimant and assessed it at 32%. However, in his cross-examination, PW2 has fairly considered that except the discharge summary produced by the claimant before him, he has not gone through any other documents for assessment of the disability. Thus, it is only based upon the discharge summary and the clinical examination of the claimant, he has assessed the disability. However, the very same witness in his cross-examination has stated that the said disability of 32% is only to the particular limb, whereas to the whole body, the said disability would be only at 5%. As such, it is the said 5% as the percentage of disability affecting the future loss of income of the appellant, claimant, is to be taken into consideration. Undisputedly, the age of the claimant was 45 years as at the time of the accident, as could be seen in the wound certificate at exhibit P6, charge sheet at exhibit P7, discharge card at exhibit P8, a disability certificate at exhibit P8, discharge card at exhibit P10, and also by the evidence of PW2. As such, the multiplier applicable to the said age is 14. Thus, towards the loss of future income, the appellant claimant is entitled for a compensation of a sum of rupees 12,500 into 12 into 14 into 5 by 100 equals rupees 1,05,000. Barring the above, no other compensation in total table. Thus, the claimant is entitled for a total compensation of sum of rupees so and so. Madi, liability apportioned among the respondents by the tribunal at 25% to the owner and respondent number 1 and 2, and 75% to the respondents 3 and 4. The rate of interest ordered upon the awarded compensation amount remains unaltered. After the deposit of the respondents to deposit the awarded amount according to their share within 3 weeks from today. After the deposit of the said amount, 50% of the same be released to the claimant of his due identification and in his accordance with law, and remaining 50% be deposited in his name in any nationalized bank for a fixed term deposit for a period of not less for a period of 3 years. There shall be no premature closure of the deposit or creation of any charge upon the said deposit without the leave of the tribunal. After the maturity of the said deposit, the entire proceeds, including the accrued interest thereupon, be released to the claimant after his due identification without any further order by the court. from modified. Award accordingly. 284,158. You get 284% enhancement. Sake. What's next?
Number 51. Sri Sita Ramrao, BC, Ketan B for R1. Along with connected matter.
ಮುಂಚೆ 5960 ಒಮ್ಮೆ ಕೂಡಿಸಿಬಿಡಿ. ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ ಅದನ್ನು ತಗೊಂಡು
Number 59. What do you put this on there? Look at the details to the matter. If that's the case, you know, we need that. Whiteboard, not the exactly before the song. I agree that.
Make use of the microphone.
I agree that, but in this matter, I oversight. A mistake is there. Pain recovery is there, man.
Then it is not possible in local.
Okay, not possible.
Counsel for the appellant will present and submits that in view of the fact that the impugned judgment orders for pay and recovery to the insurance company, the matter cannot be settled in Lok Adalat as such. Do not press. As such, would withdraw the memo while seeking the reference of the matter to Lok Adalat. In view of the above submission and also in view of the fact that the respondent have not consented for referring the matter to the Lok Adalat, the memo seeking reference of the matter to Lok Adalat stands disposed as not pressed. Just to call for PCR on an emergent basis and lift the matter immediately after receipt of PCR. Yes, both the matters.
Probably the other matters except serial number 51 would not be taken up today. The other councils need not wait.
Serial number 54.
54 ನಲ್ಲಿ appear ಆಗದವರೆ dismiss ಅನ್ನೋದು ಆರ್ಡರ್ next week carry over ಆಗುತ್ತೆ. ಒಂದು ನಿಮಿಷ ಇರ್ರಿ, ಇವ್ರು ಲಾತೂರ್ ಸುರೇಶ್ ಅವರು ಇದ್ದಾರೆ. 54 next week.
54 next week. Okay.
ಒಂದು ನಿಮಿಷ ಇರ್ರಿ ಲಾತೂರ್. Respondent counsel submits that the citation set to have been filed by you is not referred to the counsel for the respondent. ಅದು ಯಾವ citation ಏನ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಕೋರ್ಟ್ಗಂತೂ ಬರಲ್ಲ ಅವರು. ನಂಗೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಫೋನ್ ಅಲ್ಲಾದ್ರೂ ಹೇಳಿದ್ರೆ ಸಾಕು, ಅದನ್ನು ಹೇಳ್ತಿಲ್ಲ ಅಂತ ಪ್ರಮೋದ್ ಹೇಳ್ತಿದ್ದಾರೆ. ಇಲ್ಲಿದೆ ನೋಡಿ, ಫೈನಲ್ ಇರ್ತದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೇನೆ, ಅದ್ ಏನಿದೆ 2 ಸೈಟ್ ರೆಫರೆನ್ಸ್ ಬರ್ಕೊಂಡು ಹೋಗಿ ಬಿಡಿ, ಮುಗೀತದೆ. ಕೊಟ್ಟಿಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನೀವ್ ಹೇಳೋದು, ಕೊಡ್ತೀನಿ ಅಂತ ಅವ್ರು ಹೇಳೋದು.
ಒಂದೇ ಇದೆ 2009 ACJ 406.
ಅದನ್ನ ಅವ್ರು ಬರ್ಕೊಳ್ತಾರೆ ಬಿಡಿ, ಫೈಲ್ ಕೊಟ್ಟಿದ್ದೇನೆ ಅವರಿಗೆ. ಆಯ್ತು, ನಿಮ್ಮ ಜವಾಬ್ದಾರಿಯು ಮುಗೀತು, ಅವರ ಜವಾಬ್ದಾರಿಯು ಶುರುವಾಯಿತು. ಎಸ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ. Since court time is over, the matter could not be taken up today. Yes, please.
Also directed me to produce
Serial number
58 minutes. Separate copies of the deposition and petition. Got it, my lord.
Got it.
Got it, and also exhibition petition is pending.
ನಾಡಿದ್ದೆ ತಗೊಳ್ಳುವ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಫೈಲ್ ಪ್ರಿಯದೇನದು
ಬಿಡ್ತೀನಿ ಅಂತ ತಾವು ಹೇಳಿದ್ರಿ ಲಾಸ್ಟ್ ಸರಿ ಇಲ್ಲ
ಮುಗಿಸಿ ಬಿಡ್ತೀನಿ ಅಂದ್ರೆ ಮುಗಿಸಿಲ್ಲ ಅಂದ್ರೆ ಜೀವಾಧಾರ ಸಿಕ್ತಲ್ವೇನ್ರಿ? For the appellant present. Respondent Vakil Court Sri Srinivasa, serial 58. Counsel for respondent not present. Just a matter on 31/3/2023 and the top of the list. Topic ಬರ್ತದೆ 31ಕ್ಕೆ. ನಾಳೆ ಬಿಟ್ಟು ನಾಡಿದವ್ರಿ, ನಾಡಿದ್ದು ಟಾಪ್ ನಲ್ಲಿ ಬರ್ತದೆ, ಮುಗಿಸಿ ಬಿಡುವ. 31/3.
Sri Sitaram Rao BC, Sri Chetan B for R1.
ಕುಡಿ. ನಿಮ್ಗೆ ಇಬ್ಬರಿಗೂ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಬಹಳ ಸಮಯ ಇದೆ ರೀ. ನಿಧಾನ ಮಾಡ್ತೀರಿ, ನಿಧಾನ ತೆಗಿತೀರಿ, ನಿಧಾನ ನೋಡ್ತೀರಿ. ನೀವೆಲ್ಲ ಫಸ್ಟ್ ಓದ್ತೀರಿ, ಆಮೇಲೆ ಕೊಡ್ತೀರಿ. ಎಷ್ಟು ಚುರುಕಿರ್ಬೇಕು. Exhibition deposition CD. Common judgment in 2 connected MFAs. MFA 6292 of 2017 connected with MFA 7058 of 2017. Serial number 51. Summary of the case of the claimant.
serial 7058 of 2017 is of the claimant. Manifest 6292 of 2017 is of the insurance company, which was the second respondent before the tribunal. Summary of the case of the claimant before the tribunal was that on the date 3/4/2014, at about 2:30 p.m., by himself, joined by his brother Sampath Kumar, were returning from their agricultural land and were near Karadevu village cross. A borewell lorry borewell rig vehicle, so the bracket bearing registration number KA01MJ7092, being driven by its driver in a rash and negligent manner and in high speed, dashed to them. Is that road traffic accident? He sustained, the claimant sustained injuries to all over his body. Immediately, he was shifted to SSM hospital in an ambulance. From there to BGS Global Hospital at Bengaluru. Claimant has also stated that he has undergone surgical operation and was inpatient in the hospital for 2 months and has spent a sum of ₹3 lakh towards medical expenses. Stating that prior to the accident, he was hale and healthy and used to earn a sum of ₹10,000 per month by doing agriculture work as well as milk vending business. However, due to injuries suffered by him, he has totally lost his income. Has claimed a compensation of a sum of ₹10 lakh from the respondent number 1 and 2, assigning them as the owner and insurer of the alleged offending motor vehicle bearing registration number KA01MJ709. In response to the notice, despite service of notice, respondent number 1 remained absent, as such was placed expert. It is respondent number 2 / insurance company which appeared through its counsel and filed its statement of objection. Statements of objection, wherein it denied the occurrence of the road traffic accident alleged in the claim petition. On the other hand, it took a specific contention that no road traffic accident as alleged by the claimant has ever taken place. It specifically stated that the accident, the incident of the claimant sustaining injury has taken place in some other incident, but not in a road traffic accident. However, with an intention to claim the compensation, the claimant by his afterthought has falsely implicated the vehicle in question. With this, apart from this, it also denied the alleged sustenance of injury by the claimant in the incident and his age, income, avocation, and alleged permanent disability. So court examined those. It is seeking the enhancement of the compensation, not being satisfied which is the quantum of compensation awarded by the tribunal and seeking the enhancement of compensation. The claimant before the tribunal has preferred MFA 7058 of 2017, whereas being unhappy or questioning the liability upon it by the tribunal, the respondent number 2 insurance company has preferred MFA 6292 of 2017. Please. MFA 7058 of 17. ಮಾಡಿರಿ ಅದನ್ನ ಟೈಟ್ಲ್ ಮಾಡಿ ಬೋಲ್ಡ್ ಅಂಡರ್ಲೈನ್. This appeal preferred by the claimant is only seeking enhancement of the compensation. As such, leaving the aspect of the occurrence of the alleged road traffic accident as contended by the claimant in his claim petition and finding of the tribunal on the said point and fixation of liability to pay compensation upon the respondents to be discussed in the connected appeal MFA 6292 of 2017, comma, the only correctness of quantification of the compensation awarded by the tribunal is being considered. Is being considered in this appeal. Is being considered now. In support of his contention, the claimant got himself examined as PW1 and got examined his brother Sampath Kumar as PW2 and a cousin brother Chandrasekhar as PW3 and an orthopedic surgeon, Dr. Raju KP as PW4. Got marked documents from exhibits P1 to exhibits P20. PW1 in his evidence has stated that in the accident he sustained traumatic brain injury, left temporal polar extradural hematoma, left mandibular fracture, right? Any HEMI-LE, got a type 1 fracture, Right clavicular displaced fracture. Right side multiple rib fracture. Right sided subcutaneous emphysema. EMPHOACMA, emphysema. The wound certificate at exhibit P3. Evidence of PW4, the doctor mentions the nature of injuries sustained by the claimant in the alleged incident as below. PW4 only, exhibit P3 only, one day injury, whichever is more convenient to you, you can copy. According to PW1, he has undergone surgical operation by being inpatient in the hospital. Thus, he must have suffered considerable pain due to the injuries suffered by him. It is considering all these aspects, since the tribunal has awarded a compensation of the sum of rupees 1 lakh under the head of pain and suffering. I do not find any reason to modify the same. It is only the MFA title put kudle. This slow ಹೇಳ್ತೇನೆ ಓದಿದ್ದೀರಿ ನಾನು ಅಷ್ಟೇ ಗಟ್ಟಿಯಲ್ಲಿ ಡಿಟೇಷನ್ ಕೊಟ್ಟರೆ
This appeal is preferred by the client only. Of the point, the compensation amount we discussed in the connect 6292 of 2007. Yeah, the only. So, quantification of the compensation awarded. That now, in support of this contention.
In support ಮುಂಚೆ ಅದು ಪ್ಯಾರಾ ಆಗ್ತದೆ ಎರಡು ಪ್ಯಾರಾ ನಡುವೆ ಇನ್ನೊಂದು ಪ್ಯಾರಾ ಸ್ಟೇಟ್ಸ್. They are counsel for the appellant. 7058/2017. Counsel for the appellant bracket ನಲ್ಲಿ claimant. So, in his argument submitted that he would seek enhancement of compensation under the heads of loss of income due to disability, which is on the lower side, as the notional income taken is at lower side, and about not giving any compensation towards loss of amenities and loss during laid up period. This is submitted that reconsideration of compensation under these three heads be made. Supplier per contra, learned counsel. For respondent number 2, insurance company, who is also the appellant in connected MFA 6292 of 2017, submitted that since in the connected appeal filed by the insurance company, the very liability of the insurance company to pay the compensation question the liability of insurance company to pay compensation ordered by the tribunal or its enhancement would arise only after considering as a liability. As such, he would not address any argument on the point. As such, but with this, he did not address argument in MFA 7058 of 2017. This was available. Does not warrant any interference. Even though the claimant as PW1 stated that towards his medical expenses he has incurred, towards his treatment he has incurred a medical expense of ₹5 lakh. However, the medical bills and prescriptions produced by him at Exhibit B16 Exhibit B14, Exhibit B14, Exhibit B16, and also the possible other medical expenses. The tribunal has awarded a sum of ₹2 lakh as compensation. I do, since the said amount being very reasonable and just, the same does not warrant any interference at the hands of this. It is after considering the attendant circumstances, the laid up period, the necessity of attendance, diet, food, conveyance, since the tribunal has awarded a sum of ₹7,000 towards attendant charges, 10,000 towards food and nourishment charges, and a sum of ₹5,000 towards conveyance charges. They do not deserve any enhancement by this court as the said amounts are reasonable. It is after taking into consideration the evidence of PW1 and PW4, the doctor, the tribunal has awarded a sum of ₹25,000 towards future medical expenses. The same does not warrant any interference by this. The claimant has contended that at the time of accident, he was doing agricultural work and doing milk vending business and was earning a sum of rupees 10,000 per month. Since they said statement regarding income was denied by the respondent and no documents corroborating the evidence of PW1 about his income was produced by the claimant, the tribunal has taken the notional income, has decided to take, the tribunal had decided to take notional income of the claimant as his income at the time of accident. However, in the said process, it took the notional income at rupees 6,000 per month. Admittedly, the alleged incident is said to have taken place in the year 2014. For the said relevant year, a large number of motor accident claims tribunal in the state are taking the notional income at rupees 8,500 per month. Considering the age of the claimant, which undisputedly was 27 years as at the time of incident, as such the standard multiplier applicable was 70. The tribunal has assessed the loss of income with those inputs. In the said process, the inputs. PW4, the doctor has stated in his evidence that he has examined the claimant and has assessed the disability at 41.83% of upper limb. However, the total body disability was 14%. The tribunal has accepted the said percentage of disability at 14% to the whole body only. The whole body only. Thus, the quantum of compensation towards loss of income due to disability, bracket future loss of income, to come to rupees 8,500 into 17 into 14 divided by 100 equals rupees 2,42,760. Since the tribunal has awarded a sum of rupees 1,71,360 under the said head, the claimant entitled for the differential amount of 71,400 as enhancement. The tribunal has not awarded any compensation for loss of amenities. Considering the nature of injury sustained by the claimant and his avocation at the time of accident, I am of the view that he is entitled for a sum of rupees 10,000 as compensation towards loss of earnings. The tribunal also has not awarded compensation towards the loss during laid up period. The evidence of PW1, PW2, PW3 coupled with the patient recorded exhibit P17, hospital recorded exhibit P18. We go to show that the claimant, apart from being treated as inpatient, was also required to take rest for some time. Thus, 2 months period can be taken as his laid up period. For the said period, loss of income, he is entitled for a compensation of a sum of 12,000, 8,500 into 2. What's rupees? 17,000. Barring the above, so and so. B. Appellant in MFA 7058/2017 to be the claimant before the tribunal is entitled for the above calculated differential amount as enhancement provided the injuries suffered by him, which are discussed above, or occurred in a road traffic accident involving the borewell lorry borewell rig bearing registration number so and so, and at the rash and negligent driving of the said vehicle by its driver. This issue of alleged road traffic accident has been very seriously disputed by the appellant in MFA 6292/2017, who was respondent number 2 insurance company before the tribunal. Therefore, the entitlement of the claimant for compensation, the original compensation awarded by the tribunal, as well its enhancement, as well its proposed enhancement, as analyzed above, would avail to the benefit of the claimant only in case the appellant in MFA 6292/2017 fails. Whereas subtitle MFA 6292/2017. The appellant, who is the insurance company in this appeal, has seriously disputed the occurrence of the road traffic accident on the date, time, and place mentioned by the claimant in the claim petition. Also, involvement of the borewell rig-mounted lorry bearing registration number KA07MJ709. In that regard, the appellant as respondent number 2 before the tribunal has taken specific contention denying the occurrence of the road traffic accident in the manner alleged by the claimant, and also the involvement of the alleged forward mounted lorry bearing registration number KH01MJ709. Thus, the very first issue framed by the tribunal was issue number 1. However, after recording the evidence led by both sides, the tribunal has answered the said issue one in the affirmative, holding the respondents, which enabled it to hold both the respondents before it as jointly and severally liable to pay compensation. Both the respondents were done. Last again, few words.
According to the evidence led by both sides, the tribunal has answered the said issue number 1 in the affirmative. It enabled it to hold that
The second respondent insurance company before it to deposit the compensation amount. In order to prove the occurrence of the alleged road traffic accident in the manner as agitated in the claim petition, claimant Shri D.L. Mohan got himself examined as PW1 and got his one of the elder brother, Shri Sampath Kumar as PW2, and his cousin brother, Shri Chandrasekhar as PW. Both PW1 and PW2 in their examination chief have stated that at the time of the accident, both of them were coming from their agricultural land. Beginning date of consent occurred on 3/4/2014 at 2:30 PM ಅಂತ ಹೇಳಿದ್ದಾರೆ. AM midnight. Both of them were returning home in the midnight, watering their land. At about 2:30 AM near Karadevu village cross, where they were walking on the side of the road. The driver of a borewell rig lorry bearing registration K01MJ7092 came in a rash and negligent manner at high speed and dashed against them, resulting in a road traffic accident. It is in the said road traffic accident, PW1 sustained multiple grievous injuries. Both these witnesses further stated that immediately after the accident, summoning an ambulance, claimant number 1, summoning an ambulance, PW1 was shifted to SSM hospital. From there to BGS Global Hospital at Bengaluru, where he was treated as an inpatient. PW2 has stated that it was him, joined by his father and cousin brother, Shri Chandrasekhar, shifted injured PW1 to the hospital in ambulance and admitted him to different hospitals. different hospital. PW3 Chandrasekhar has stated that after the accident, it was PW2 himself and father of PW1 shifted the injury in the ambulance to hospital. Ambulance to SSM hospital. From there to Niman's hospital at Bengaluru and then to BJ's hospital at Bengaluru. In support of the evidence about the alleged road traffic accident from the claimant side, copy of an FIR, copy of a complaint, copy of a scene of offense Panchanama, copy of a seizure of vehicle Panchanama, copy of motor vehicle inspector report, copy of a charge sheet, copy of a statement of PW1 before the investigating officer, were marked at Exhibit P1, Exhibit P2, Exhibit P3, Exhibit P4, Exhibit P1, Exhibit P2, Exhibit P4, Exhibit P5, Exhibit P6, Exhibit P7, and Exhibit P8 respectively. A perusal of these police documents go to show that a road traffic accident on the date, time, and place as mentioned by the claimant in his claim petition has occurred. The charge sheet at Exhibit P7 accuses the driver of Orwell rigged lorry bearing registration number KA01MJ7092 of committing the offence punishable under section 279 and 338 of Indian Penal Code. It is upon these oral and documentary evidence of the claimants, the learned counsel or the respondent number 1 in MFA 6292/2017 vehemently submitted that the finding of the tribunal about the occurrence of the road traffic accident in the manner as stated by the claimant in the claim petition cannot be found fault with. Cannot be found fault with. Stands established. The learned counsel for the appellant in MFA 6292/2017 vehemently submitted that the very wound certificate Exhibit P3 and the inpatient record at Exhibit P17 clearly go to show that as stated at the earliest point of time before the doctor and in the different hospital was that the injury was sustained by the claimant is a workplace injury
due to trauma by a pipe while working at a bore well. He further submitted that admittedly the complaint was filed 2 days after the alleged incident. As such, it is a false implication of the alleged offending lorry by the claimant only with an intention to get compensation. However, the tribunal did not notice this greater variation, but merely relying upon the alleged police document, answered issue number 1 in the affirmative, which is erroneous. He also submitted that there is nothing on record to show that in the criminal case with respect to the alleged incident, the driver of the alleged offending lorry was punished. Merely relying upon a charge sheet in the circumstance of the case, the tribunal ought not to have answered issue number 1 in affirmative. For Comptroller and Counsel for Respondent submitted, Respondent number 1, bracket claimant submitted that the evidence of PW 1 to 3 corroborates Exhibit P1 to P8 and clearly establishes the involvement of the borewell rig mounted lorry and the occurrence of the road traffic accident at the fault of the driver of the lorry. The evidence of the date of the alleged incident, both as per the claim petition and also as per the evidence of PW 1, PW 2 and PW 3 is 3/4/2014 at about 2:30 a.m. bracket after midnight. According to PW1 and PW2, after watering the crop in the field while they were returning home in the midnight, the offending lorry bearing number so and so, being driven by its driver in a rash and negligent manner, dashed to PW1, due to which PW1 sustained injuries. PW1 to PW3 have uniformly stated that immediately after the accident, in an ambulance, the injured was first shifted to SSM hospital and from there to Niman's hospital and then to BGS Global Hospital, Bengaluru. They have also produced the wound certificate at Exhibit P3, the inpatient record at Exhibit P17, and the hospital record P18 for the hospital record in the form of doctor's notes at Exhibit P18. With the cross-examination of all these 3 witnesses, specific denied suggestions were made regarding the alleged occurrence of a road traffic accident. It was categorically suggested to all these witnesses that no such road traffic accident as alleged by them has ever taken place, and that the alleged sustaining of injury
by the claimant was while working with a borewell in the land, not in a road traffic accident. However, PW1 to PW3 did not admit the such suggestion as in the light of the above oral evidence, when the documentary evidence is looked into, can notice that firstly, the wound certificate upon which the claimants have granted clearly mentioned that the patient was brought to VGS Global Hospital by Mr. Chandru, said to be the brother of the injured. With some injuries said to have been caused on 3/4/2014 due to workplace injury. The patient was brought with the alleged history of trauma by a pipe while working at a borewell. It mentions patient sustained trauma to head, face, and chest. Thus, the wound certificate mentions the cause of injury as a workplace injury, a trauma by a pipe while working at a borewell. Exhibit P17 which is an inpatient record of the hospital, but it's page number 6, bracket are also shown as 96. And page number 7, bracket also shown as 97, shows two documents as medical legal case document, two documents as a medical legal case report and a case sheet. In the said medical legal case report, that medical legal case report also, it is shown that the injured Mohan was brought to the hospital by his alleged brother Chandru. With the history of a hit by a pipe while working at a borewell and sustaining injury to head, face, chest. The case sheet at the same, the case sheet in the same exhibit at page 7 also mentions the history as
History of injury at 2:30 a.m. on 3/4/2014 near Doddakaradevu, Channapatna, and the patient was supervising a borewell installation when one of the pipes fell on him. Thus, not the pipes fell on him. Furthermore, one more document at internal page 197, okay, also shown as 113, which is shown to be a doctor's note of the same BJS Global Hospital. Dated 3/4/2014, recorded at 1:25 p.m., shows that patient had the history of a fall of iron rod over his right head, comma, face, comma, chest, and shoulder on 3/4/2014 at 2:30 a.m. near Doddakaradevu, Channarayapatna. One more document of the same hospital shown to be nurse's record, which is at page 205, bracket, also shown as page 257 in exhibit P70, which is shown to have been recorded on 3/4/2014 at 12:13 p.m. Also mentions that the patient was brought in an ambulance with the history of alleged injury hit by a pipe while working at borewell and sustaining injury to head, face, and chest. Thus, the medical records even one more doctor's note of BGS Global Hospital, which is also produced by the claimant and got it marked as exhibit P18. One more medical record, one more medical record, exhibit P18, which is a discharge summary of BGS Global Hospital. Also mentions that patient was presented with a reported history of workplace injury on 3/4/2014 when a borewell pipe fell on him. It also says that patient was initially treated elsewhere and brought to their hospital for further management.
Thus, all these medical documents which have been produced by the claimant himself in support of his case at more than one places and in different types of documents recorded at different dates and time uniformly mentions that history of injury was a workplace injury due to fall of a pipe while working near a borewell. Borewell at about 2:30 a.m. on 3/4/2014. None of these documents whispers about a road traffic accident, much less involving a borewell rig, lorry bearing registration number so and so. In order to overcome the above anomaly, the claimant got examined PW3 Sri Chandrasekhara, said to be his cousin brother, and through him got stated that he was not an eyewitness to the incident. However, due to the wrong information given to him, he has stated before the doctor in BJ's hospital a wrong history of injury. The above evidence of PW3 that he was wrongly informed about the history of injury is not acceptable for the following reasons. Small a. Firstly, it is the case of PW1, PW2, and PW3 that immediately after the alleged incident, an ambulance was summoned to the spot, and in the said ambulance, PW1, the claimant, was shifted to hospital, accompanied by PW2, PW3, and also the father of PW1. Therefore, from the earliest point of time till PW1 was admitted to BJ's hospital, this witness, bracket PW3, was accompanying PW1 and also in the company of PW2, the sole eyewitness to the alleged incident, and also father of PW1. As such, he had ample opportunity to know the exact details of the occurrence of the incident, though he was not eyewitness. Therefore, his contention that he was given a false information cannot be believed. B. PW3 in his evidence, though has shown that he was constantly accompanying PW1 till he was admitted in BJ's hospital at Bengaluru and was with PW2 and the father of PW1 till he has stated that during the said time, though he was with PW1, though he was with them, he did not bother to know as to how Mohan Kumar, bracket claimant, oblique PW1, sustained injuries. He has stated that till he gave information to the doctor in BJ's hospital, he did not bother to know the manner of
PW1 bracket claimant sustaining injury. This statement of PW3 is highly unbelievable for the reason that he being the cousin brother of PW1 bracket claimant and joined by other family members of the injured, shifting the injured to the hospital and spending much time with PW1, the injured, PW2 and the father of the injured should have necessarily gathered information or come to know as to the manner of occurrence of the injury upon the claimant. Therefore, his statement that he did not bother to know about those details is highly unbelievable. C. C or D, D address C. The very same PW3 in his cross-examination has stated that while he was near his house, the people had gathered there and were telling that borewell lorry had dashed, causing an accident. Therefore, he has stated the same in the BGS hospital. BGS hospital. Thus, PW3 himself has shown that before the injured could be shifted to hospital, he was aware by hearing the people that he was aware better. He was given to information that claimant sustained injuries in a road traffic accident due to dashing of a lorry. However, dashing of a lorry, he himself has admitted that it was him who had given information about the history of injury to the doctor at BGS hospital. However, the very same records of the said hospital shows that the history as given by the person Shri Chandru bracket PW3 accompanying the injured was that it was a workplace injury. Workplace injury sustained by the claimant due to fall of a pipe upon him while supervising a borewell installation. When PW3 contends subpara that he had stated before the doctor in BGS hospital that the history was a road traffic accident, there was no reason for the doctor to record a different version of the occurrence of the incident, public injury. If that ought to be the case, then the claimant should have necessarily examined the authors of the above referred documents of BGS hospital in exhibit, the above referred documents in exhibit P17, all of which are the documents of BGS hospital. However, for the reasons best known to them, the claimant, best known to him, the claimant did not made any effort in that regard. Therefore, the hospital record though would go to show that there is possibility of a borewell rig mounted lorry being present in the lands of the claimant, but claimant sustaining injury is not due to any road traffic accident, but by the fall of a pipe while he was supervising the installation of borewell. D ಅಥವಾ E. In Exhibit P17, the documents which records the history of injury are not single. There are at least 3 or 4. ಅದನ್ನ ಆಮೇಲೆ ಮೇಲ್ ಕೌಂಟ್ ಮಾಡಿ ಹಾಕಿ ಮೇಲೆ ಹೇಳಿದ್ದೇನೆ ಬೇರೆ ಬೇರೆ ಪೇಜ್ ನಂಬರ್ ಸೋನ್ಸೋ 3 or 4 different documents including MLC case register sheet recorded by different persons at different timings. Some are by doctor, some are by nurse, and some may be by the admission section in the hospital. However, all of them have recorded that as informed to them, the history of injury was due to fall or hit by a pipe while working at a borewell in the workplace. If at all PW3 has given a wrong information to any one of the author of those documents who has written the history as given to them by PW3, but there cannot be any reason for the different persons recording the same history at different timings in different sections of the hospital. It is not the case of claimant that PW3 has given the statement about the history of injury before all of them in the hospital who are all have recorded those histories at different sections and different timings. As such also, it clearly stands established that the incident of claimant sustaining injury was happened in some other manner, maybe by fall of a borewell pipe while installing the borewell, but not in a road traffic accident. In addition to the above paragraph, there is one more document in Exhibit P70. ಇದೊಂದಕ್ಕಿನ್ನ ಫ್ಲಾಗ್ ಹಾಕ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ನಲ್ರಿ ನಿಮ್ಹೆನ್ಸ್ ಇಂದೊಂದು ಫೈಲಲ್ಲಿ ನಿಮ್ಹೆನ್ಸ್ ಅನ್ನೋದೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಇಟ್ಟಿದ್ದೆ ನಾನು ಇಲ್ಲ ಫಸ್ಟ್ ಅಲ್ಲ. There is one more document in Exhibit P70 which does not belong to BJ's Global Hospital but pertains to Nimhans, Bengaluru. That is the very first document in Exhibit P70, which document also clearly go to show that the claimant, the injured Sri Mohan was brought to their hospital by one Sri Girish, said to be a friend of the injured, with the history of injury due to hit by a pipe while working at a borewell.
The said document has been produced by none else than the claimant himself, and he has nowhere whispered that that the recitals in the said document was wrong. On the other hand, PW 3 himself has stated that before the injured claimant was taken to BGS Global Hospital at Bengaluru, he was first taken to Nimhans at Bengaluru. From there, he was taken to BGS Hospital. Therefore, even the hospital record of Nimhans, where the information is given by, information is not given either by PW2 or PW3, also mentions history as hit by a pipe while working at a borewell. Lastly, even in the hospital record, lastly, in addition to the above, aduna lastly into madi. In addition to the above, the para lastly into madi. Lastly, mail and para insert madi. In addition to the above, the hospital record, the BGS Global Hospital recorded at Exhibit P70 in its internal page 7 bracket, also shown as 97, shows the history with which the patient was brought was injury at 2:30 a.m. on 3/4/2014 near Doddakaradevu, Channapattana, while the injured was supervising a borewell installation when one of the pipe fell on him. It is also shown in the very same document that the said history was given by Lingaya Gowda, the father of the injured. The father of the injured. Undisputedly, even according to PW1, PW2, and PW3, the said Lingaya Gowda, the father of the claimant, had also accompanied the injured to all these hospitals. All these hospitals. It is not the case of PW1 or PW2 that their father, Lingaya Gowda, was not aware of the true history of the injury caused to true history of the injury sustained by PW1 bracket claimant. Thus, claimant said Lingaya Gowda was not examined by the claimant for the reasons best known to them. Therefore, the evidence of none else than the father of the evidence. Therefore, the information shown to have been given by none else than the father of the claimant about the history of injury upon PW1 finds no reason to disbelieve it. Lastly, all the above analysis clearly establish beyond any doubt that all these are lastly munche one more aspect lastly in the light of the above subpara, the delayed filing of information with the police
by 2 days also creates a serious doubt. PW2, the brother of the claimant, who is also said to be eyewitness to the alleged incident, in his cross-examination, has categorically stated that all of them have stated in the hospital as to how the incident has occurred. He has also stated that they had no inconvenience or difficulty to lodge a complaint with the police. Lodge a complaint with the police, even while the injured was no inconvenience or difficulty in lodging the complaint. Thus, when there being no inconvenience or difficulty to lodge the complaint with respect to alleged road traffic accident immediately after the incident or without further delay, they have taken more than 2 days that is from 2:30 a.m. on 3/4/2014 up to 5 p.m. on 5/4/2014 to lodge the complaint with the police. This is nothing. This will also add one more doubt to the series of doubts in the case of the claimant about occurrence of the road traffic accident. Therefore, it stands established beyond reasonable doubt that the claimants have utterly failed to prima facie show or establish that the injury sustained by PW1 bracket claimant was due to a road traffic accident and said the road traffic accident was involving a borewell rig mounted lorry wherein registration number so and so. However, the tribunal, without analyzing the evidence placed before it in its proper perspective, has straight away jumped to a conclusion based upon police document holding that the claimant have proved issue number 1 in affirmative. Since the said finding on issue number 1 now being found erroneous, the order of the tribunal holding the respondents liable to pay compensation to the claimant, this has to be set aside. Consequently, MFA 6292 of 2017 as deserves to be allowed, and MFA 7058 of 2017 deserves to be dismissed. Accordingly, I proceed to pass the following order. MFA 6292 of 2017 stands allowed. The judgment and award dated so and so passed by so and so stands set aside. The claim petition filed by the claimant in MEC number so and so stands dismissed as devoid of merit. MFA 7058 of 2017 stands dismissed. There is no order as to cost from modified award accordingly. Registry to transmit. University.